Password. Password ಇದಲ್ಲ? Password. ಕಲ್ಬಿಟ್ಟು. Yes. Yes.
Petitioner permission.
Yes.
Prayer is to quash annexure F insofar as granting the promotion to the third respondent as a court officer. The dates would be relevant to know. The petitioner is appointed as a second divisional assistant on 5/6/2009.
Yes.
The SDA on 5/6/2009. Entry into service, the initial entry into service is SDA. Then the third respondent is appointed as typist on 1/4/2010. It's almost 10 months after the 1/4/2010.
Yes. Who is that third respondent?
Third respondent appointed as typist.
Yes.
Then the petitioner is promoted to the post of first divisional assistant on 25/2/2015.
No, he has been appointed as an SDA.
Petitioner was first appointed as SDA on 5/6/2009. Then promoted to the post of FDA on 25/2/2015. 2015.
FDE.
Yes. The respondent number 3 is promoted from the post of typist to the post of FDA on 20th August 2015.
Yes.
So here both of them enter the cadre or post of FDA. One enters earlier on 25th of February.
Yes.
The other enters on the 20th of August 2015.
Yes.
There is a final seniority list of the FDAs of the local cadre.
Yes.
Both of the petitioner as well as the respondent number 3 belong to the local cadre, and therefore this local cadre final seniority list of FDAs is published on 31/12/2019.
Yes. 31/12/2019.
That list is at annexure B, which starts at page 28.
Yes. Yes.
My lords, will see the seniority of the petitioner vis-a-vis the respondent number 3 therein. Petitioner obviously shown as senior to the respondent.
Serial number?
Yes, serial number 4 and serial number 12 respectively.
Serial number 4 is that petitioner.
Petitioner.
5 is that respondent. No.
Annexure B.
Annexure B.
Yes. 4 and 12. It starts at page 28.
Yes. 4 and 12.
Yes. Number 4.
Yes.
The date of birth is 6/12/1984. 5/6/2009 is the date of entry into service, and date of present post is stated as 25/2/2015. Then at serial number 12 in page number 29.
Yes.
My lord will find the date of the name of this respondent number 3.
Yes.
Date of birth. Then 1/4/2010 entry into service, 20 August 2015.
Yes.
Now thereafter on 9th of June 2021 and on 14th of June 2021, these are the dates of signing the orders of further promotion to the petitioner as well as respondent number 3. Now that both these persons from the post of the cadre of FDA are entitled to choose between 2 further promotional posts. One post is the senior assistant post, other post is the post of ACO. Now both of them give different options is what I am made to understand, and the respondent number 3 gives the option to be chosen as a senior assistant for the further promotion in the local cadre, whereas petitioner chooses to be an assistant court officer, and both of them are made aware that both these posts fall in one category. And
where is that rules which provided for promotion to the two different cadres?
The rules,
from the SDA.
the rules are, yes, the rules are at annexure F, my lords will see. It is also up, filed by the respondents 1 and 2.
Yes.
As per the statement of objections at annexure R1. Annexure R1.
Yes.
Sorry. The statement, my lords will see annexure R1. I think they have filed it.
Yes. Yes. Condition service recruitment.
Page 22 to 41 to the statement.
Yes.
And the relevant rule for the purpose of FDA.
Yes.
Page number 28.
Yes.
Number 15. First divisional assistants and audit clerks by promotion from the cadre of SDAs and typists.
Yes.
In the ratio of 6:4, 6 SDAs and 4 typists.
Yes.
As far as possible, provided that an official of one of the above two cadres shall not be given promotion to the cadre of FDA or audit clerks earlier to the promotion of the officials of the other cadre who had become members of that cadre prior to the date on which the former official become a member of his or her cadre.
Yes.
Whoever is senior, he should be given first promotion is what they probably mean.
Yes.
Provided they shall possess a degree from any university established by law in India and certificate course in computer application.
Yes.
Both the petitioner as well as respondent number 3 claim to have obtained this degree in law also. The ratio is 25% of the vacancies to be filled up by promotion from the cadre of SDAs and typists having degree from any university established by law. Then 75% of the vacancies to be filled up by promoting the second divisional assistants and typists based on common seniority list on seniority cum merit basis, regardless of whether they possess degree or SSLC qualification, provided they have completed 2 years of satisfactory service in the feeder cadre. The ratio of promotion between the feeder channels mentioned at 1 and 2 above shall be 1:3. Then from here at serial number 14, at page 29, senior post of senior assistant.
See here, 25% vacancies to be filled up by promotion from that cadre of SDA
and typists. Having degree from any university established by law in India. Based on common seniority.
Yes.
In those cadres, provided they have completed 2 years of satisfactory service.
75% of the vacancies to be filled up by the promoting again.
The SDAs and typists based on common seniority list on seniority cum merit basis.
Yes. Yes.
Whether they possess
seniority and merit both.
If they possess probably the law degree, then 25% of those vacancies have to be filled up by persons holding mandatorily the law degree. The 75% is by those who don't hold that law degree mandatorily.
Yes.
And the requirement is a common seniority list.
Yes.
That common seniority list. And thereafter, the next promotional avenues are at serial number 14 in page 29 and serial number 21 at page number 32.
Yes. Now that your claim in respect of that senior assistant.
Senior assistant is the position which the respondent number 3 chose, and he was promoted to that post. I am not having a grievance about his promotion to that post.
Yes.
The statement of objection entirely speaks about my right or locus to challenge the promotion granted to the respondent number 3.
Yes.
I have absolutely no grievance. He should be promoted as per his seniority. I should be promoted as per my seniority. Merely because somebody else is promoted, that should not affect my seniority vis-a-vis his standing in the list. That's my grievance.
Now that where is that
now I am
for court officer?
Yes, that is the senior assistant is at page number 29, whereas assistant court officer will be found at page number 37 and court officer at page 38.
Yes.
Shall I read to your lordships page 29, senior assistant?
Yes.
How they are to be chosen.
Yes.
by promotion on the basis of seniority come efficiency from the cadre of first divisional assistants, accountants, audit clerks, assistant librarians working in the High Court, provided they shall possess a degree from any university established by law in India or equivalent. Explanation 1, the present members who are working as senior assistants and who do not possess the required qualification shall qualify themselves without affecting the regular work with prior permission of the Honorable the Chief Justice within a period of 5 years, failing which they shall not be entitled for further promotion.
Yes.
The permission is not automatic but subject to the interest of the institution. Such permission shall not take away the rights of the senior employees and does not confer the undue privileges on the junior employees. Qualification obtained without following the above norms would not be taken into consideration till they come within the zone of consideration.
Yes.
For securing minimum qualification prescribed for this cadre within stipulated time, the permission may be liberally granted. Period of time prescribed for securing minimum qualification, that is 5 years, starts from the date of permission. Then, my lords, will see 25% of the vacancies to be filled up by promoting the first divisional assistants or audit clerks, accountants working in High Court, having degree from any university established by law in India, provided they have completed 2 years of satisfactory service in the feeder cadre.
Yes.
75% of the vacancies to be filled up by promoting FDAs, audit clerks, accountants working in High Court based on seniority come merit, regardless of whether they possess degree or SSLC qualification, provided they have completed 2 years of satisfactory service in the feeder cadre.
Yes.
Ratio of promotion between the feeder channels mentioned at 1 and 2 shall be 1:3.
Yes.
So one in that 25% slot and the 3 in the. Then, my lords, the another option for an FDA to be promoted is ACO. Kindly see page number 37, entry 14A.
Yes.
This is by promotion on the basis of seniority come efficiency from the cadres of stenographers and first divisional assistants, audit clerks, accountants, and assistant librarians who possess degree in law of a recognized university in the ratio of 1:4. If no eligible candidate is available for promotion from among stenographers, first divisional assistants, audit clerks, accountants, and assistant librarians from the cadre of second divisional assistants or typists in the ratio of 1:1 who possess the law degree, or by selection from the cadre of Shirastedar working in the subordinate courts who possess a degree in law of a recognized university. Then by promotion on the basis of seniority come merit from the cadres of first divisional assistant, audit clerks, or accountants who possess degree in law of a recognized university, provided that they have completed 2 years of satisfactory service in the feeder cadre. If no eligible candidate is available for promotion from among first divisional assistants or audit clerks, accountants in the High Court of Karnataka, then by selection from the cadre of first divisional assistant and above cadres working in the subordinate courts who possess degree in law of a recognized university.
Yes. Now, what has happened to this case?
Now, in this case, both the petitioner as well as respondent number 3 respectively were entitled for consideration for the next promotional post from the post of FDA.
Yes.
On a particular singular date.
Yes.
On that date, they were entitled to hold either of the two posts, both the post of senior assistant or the post of assistant court officer.
In both cadre, there was a vacancy.
Yes, there was a vacancy. Both the files were moved on the same day.
Yes.
The difficulties probably seems to be that one order, both of them are entitled on that particular day for consideration.
Yes.
Both of them are held to be entitled for promotion, and they are given the promotions. The orders of promotions are passed, one on 9th of June 2021 in favor of the respondent number 3.
Yes.
And the other in favor of petitioner on 14th of June 2021.
1/6/20.
One is 9/6/2021.
9/6.
This is in favor of the respondent number 3, who becomes a senior assistant from the post of FDA.
Senior assistant.
And so far as the petitioner is concerned, though she is senior to the respondent number 3 in all other respects,
yes,
the order is passed on 14/6/2021.
Yes.
Promoting her from the post of FDA to the post of assistant court officer.
Yes. Yes.
There was no occasion, my lords. The statement of objection rather says I should have objected in the year 2021 itself when promotion was given to the respondent number 3. I fail to understand, my lords, how I could have, my lords, understood or made aware that somebody else in the cadre is given some posting of a promotion by way of an order, which is subsequently after 3 years going to affect my seniority. Nobody had even disclosed what is the list of senior.
Next seniority.
The next defect is from the posts of assistant court officer and the post of this senior assistant. The next promotional avenue was the court officer's post. Now it's here a common seniority list of the two posts ought to have been made, ought to have been published, so that I could have understood where I stand in relation to.
Now that next post is that
court officer.
Court officer.
Court officer.
What are that?
That is at page number 38, serial number 12.
Court officer. Yes.
Rules are wrongly added. After 15 we get 14, then 12. At serial number 38, court officer.
Yes.
By promotion on the basis of seniority cum efficiency from the cadres of two cadres of assistant court officers and senior assistants who are law graduates, seniority being reckoned on the basis of length of service in the cadre.
Yes.
By promotion on the basis of seniority cum merit.
Oh, now length of the service. Now they are taking that
length of service.
Yes.
Length of service from the feeder cadre. Obviously, feeder cadre are now not one. There are two feeder cadres. Now they are saying we will see the respective length of service in that each feeder cadre. You are appointed 6 days prior to my appointment or promotion.
Oh, that is
that's the whole difficulty.
Yes. Now, signing up that promotion order is that only a defect. That's what that your grievance. Otherwise,
promotional order is only signed on 2 different dates. That should not merge. If this is permitted, that the authority can sign on 2 different dates, and that authority also is not having the entire control over the files. The movement of the file happens from several offices and several officers.
If both that promotion order has been signed on the same day, what will be that effect? Who will be the senior?
The petitioner, obviously. That is the only seniority list published is of the year 2019, where I am shown at serial number 4, senior 2, the respondent number 3, who is at serial number 12.
Yes.
Now there is no other seniority list, combined seniority list of these two cadres for the petitioner as well as respondent number 3 or others who might have been aggrieved also.
Yes.
To say what were their standing in that list. Nobody knows where they stand in that combined list. Now everybody is getting their orders on a specific date, and nobody is even allowed to go and verify as to who gets the orders of promotion signed on which date, and nothing is of that sort is known. Now in this kind of a case, whether it's a negligent action or it is a deliberate action, that is something which is not in the domain of the parties at all to submit. So if this is not within their power, there is no question of now saying that the petitioner ought to have challenged that promotional order of the respondent number 3.
Yes.
So if I stand senior, if this fact as a fact, if I stand senior in the cadre of FDAs,
yes, and
thereafter, my lords, can there be any promotion given to somebody else over and above me, making me junior to the person who is otherwise junior to me? Will that have the effect of taking away my right to be considered for the next promotional avenue? I am not saying that I am entitled for this promotion. Nobody can say that they are entitled.
That order of that promotion has been passed in the 2021.
Yes.
When that writ petition is filed.
I am not challenging that 21 order at all.
No,
this is filed in 2024 when.
Now that they only looked into that.
Yes, that is the.
Now that what has happened to that earlier, which is not challenged, now it cannot.
I am not challenging that also, my lords. Now what they do is they pass this subsequent promotional order in 2023.
Yes.
And grant the subsequent promotion to respondent number 3
on the basis of the length of service
in that feeder cadre is what they say.
That's what the rules also says.
Yes. Now how did the authority ascertain that I am not senior to the respondent number 3 from why not a seniority list to be published, a combined seniority list to be published? I cannot. How is the employee entitled to understand where does he stand in the seniority list?
No,
this becomes contrary to the transparency.
Is your case that without
yes
publishing that common seniority list, they cannot be?
Yes, that is my first point.
Yes,
that there has to be some indication to make the employees aware about their standing vis-a-vis the other employees, so that they can understand whether they will be considered for the promotion or they will not be. If they are not considered, for what reason they are probably left out. Otherwise, my lord, this would, if your lordships are saying that the orders of earlier promotions will be looked into by the authorities, and that will be a deciding factor only.
Aspects, if you first you have to be canvassed.
Yes.
Without that seniority list, promotion cannot be implemented.
Yes.
That is that first point. Yes. If
My-
the seniority list is announced and that objection is called for, you would have been objected. That's what
I would have objected. I could not have objected without me being made aware that I am now treated as a junior person because somebody's promotional order has come earlier to my order of promotion. I was under a sweet assumption that since both of us are considered on the particular same day itself, the orders will be signed on the same day. There is no reason given by the authority why the orders are signed on different dates. I worry, my lords, if such thing happens, that the files for promotion of two different employees are forwarded and the movements are made at different paces. And just because the movement is made at different paces, the orders are signed on different dates.
No, that if we could have challenged, then we could have answered that yes, this is wrong, it cannot be. Now can it be done it and but now the question.
How could I have challenged? Can the other side say that I had a right on 9/6/2021 when somebody among several hundreds of people were given promotions? I should have stood up and challenged everybody's promotion order. I am not made aware how it affects me, and I am essentially not challenging his promotion.
No, you have to be challenged.
I cannot, my lords, I need not challenge.
In the feeder cadre, its service is taken earlier to you.
How could I know that?
No, the moment it comes to your knowledge, you could have challenged that.
How could I know who else in the entire department is given promotions earlier to me or later than
When
me?
you have come to know that
Only when the subsequent order of promotion of the court officers is published, I come to know that he is promoted because his length in the feeder cadre is shown to be more than
you
me.
could have challenged that is also.
Immediately I have made a representation, and that is what is challenged before your lordships.
No, have you challenged that he has been promoted as a senior assistant?
I did not challenge that. How should I challenge it, Manoj? I don't have any
No,
locus.
after it come to your knowledge.
Even now, Manoj, I cannot. I don't have a locus standi in service jurisprudence, as I understand. Senior will be able to throw light on my understanding of law.
When your junior has been promoted before you,
yes,
either you can seek that I should have been promoted from the date of the junior, or you can say that his promotion is wrong. You can challenge that. Who said it?
I am not essentially aggrieved by his promotion. I am only aggrieved by the not fixing of the seniority. I am not made aware where I stand in the seniority.
That is, if you convince the court saying that yes, without the seniority lead, promotion cannot be operated, that is different. Otherwise, what that rule says that length of service, he is senior to you.
That is very.
That has to be set aside. You cannot be.
Yes. Length of service. How can length of service be reckoned? Is it only merely on the basis of the orders, the dates of the order, signing of the order, or is it on the basis of the consideration of the seniority of their service?
That will be considered from the date promotion order has been issued. If that is wrong, we can answer whether it is right or wrong only if it is questioned. Otherwise, we cannot say that. Is it not? It could have been challenged. We can say that it cannot be. Otherwise, it is in a discretion of the
independent of. Let me explain this answer. Probably I am unable to answer this. Whether the respondent number 3 was independently entitled to be promoted or not is not my grievance at all.
Yes.
I cannot come to know about this fact as to what is the date on which he is promoted, unless there is some mechanism by which I am made aware about the date of promotion.
Made it clear. I am asking that after it comes to your knowledge, you could have challenged that also.
Yes, Manoj. This is the prayer which I have made, Manoj, in my present writ petition. I have said, so far as granting promotion to the third respondent to the rank of court officer is concerned, that notification I am challenging.
Yes.
And Manoj, I have sought for a direction to grant eligibility date of promotion to the petitioner in the post of assistant court officer as on the date of promotion of the third respondent. Kindly see my second prayer.
Yes.
Now the wordings may not be as appropriate as the court wants it, Manoj, but in essence, I have asked saying that I should be treated as senior to the respondent's respondent number 3's candidature, and thereafter promote the petitioner to the rank of. This is my prayer number 2.
Yes.
I will read that much. Direct the first and second respondents to grant eligibility date of promotion to the petitioner in the post of assistant court officer as on the date of promotion of the third respondent in the rank of senior assistant, that is on 9/6/2021. I am in fact, my lords, not agreed even today. I am not saying that he should not be promoted as court officer also. He can as well hold the post of court officer. But if I am also entitled for the promotion as a court officer, why should I be denied of that?
Yes,
and your lordships are aware, my lords, why promotions are in fact conceived.
Yes,
the promotion is necessary for the very welfare of the effective working of the department itself, or the
Yes.
for the employer himself.
Yes.
Notice this is the short point involved in this case. Only if singularly we read the rule itself and say that
Now
no, the
that,
feeder cadre is the one.
Is there any judgment?
Yes,
applying?
yes.
Yes.
There was one judgment reported in 1989, supplement 2, SCC page 351. Can you give this one to the other side, please? May I pass on a copy of this judgment? Copy. It's a short judgment, Manoj, but this may throw some light on my right vis-a-vis the right of a person who is given an accelerated or a promotion at a different space.
Yes.
The relevant paragraphs are para 8 and 9, but my lords will permit me to read from the beginning.
Yes.
The facts may be relevant, my lords, because this appeal by leave is directed against the judgment of the Central Administrative Tribunal dated November 11, 1988 in OA number so and so. The events leading to the appeal are these. On February 20, 1958, Balkishan, the appellant, was enrolled as a constable in Delhi Police. On February 1, 1964, he was promoted to officiate as head constable. His confirmation as head constable was delayed on account of certain adverse remarks against him. Those adverse remarks were later expunged and he was confirmed in 1969. This has delayed his promotion as SI, sub-inspector. Complaining about the belated confirmation and seeking further promotion, he filed a writ petition in Delhi High Court. The High Court, by judgment dated September 25, 1984, allowed the writ petition and directed the respondents to confirm the appellant with effect from February 1, 1966, with all consequential benefits. The operative portion of the order of the High Court is as under. I will skip that one.
Yes.
There was no immediate compliance with this order, and the appellant had to move the High Court to initiate contempt proceedings against the respondents. To avoid action in the contempt proceedings, the respondents made, perhaps hurriedly, several orders giving the benefit of promotion to the appellant. The appellant was confirmed as directed with effect from February 1, 1966, and also promoted as ASI with effect from July 24, 1967, instead of February 25, 1970.
Yes.
Again, he was promoted as SI with effect from May 1, 1980, and confirmed as such with effect from July 5, 1983. Further, he was admitted to promotion list F with effect from February 18, 1988, and further promoted as officiating inspector with effect from April 19, 1988. As a result of these promotions, the appellant practically jumped over several of his seniors. The seniors, however, were not given corresponding promotions. They made representations complaining of injustice done to them. When the respondents realized that they had committed a serious error in giving successive promotions to the appellant, overlooking the case of seniors. On May 26, 1988, the appellant was called upon to show cause why his promotions may not be cancelled and his seniority be refixed, ranking him below his confirmed seniors. The show cause notice has also stated that upon further examination of his case, in the light of numerous representations from his seniors, promotions given to the appellant were fundamentally incorrect and illegal. The relevant portion of the notice reads as follows. Para 4. The appellant replied to the show cause notice but could not carry conviction. Additional Commissioner of Police, after considering the reply, made an order dated October 25, 1988 in the following terms. Then at para 5, challenging the aforesaid order, the appellant preferred an appeal to the Central Administrative Tribunal. Tribunal has dismissed the appeal. It has observed that the refixation of appellant's seniority and consequent revision was not arbitrary. It was consistent with the provisions of the Punjab Police Rules, which govern the service conditions of the Delhi Police. The appellant was not legitimately entitled to seniority upon which he was promoted over his seniors. It has no support from the statutory rules. His promotion to the cadre of HCs, ASI and SIs was unjustified. With this and other conclusion, the tribunal expressed the view that there was no illegality in the reversion of the appellant and it was corrective action justified under the circumstances. The order of the tribunal has been assailed in this appeal. There is no dispute that as a result of implementation of the order of the High Court, the appellant has marched over his seniors in every cadre when the appellant was promoted from cadre to cadre, his seniors were not considered for such promotions. Counsel for the appellant did not dispute this fact. He, however, urged that the seniors who were not confirmed within the prescribed time or before confirmation of the appellant were not entitled to retain their seniority above the appellant. On this aspect of the matter, we asked Mr. So-and-so, Additional Solicitor General, to have the matter re-examined by the respondent. Upon re-examination of the case of the appellant and his seniors in the light of the judgment of the High Court and the relevant rules of promotion, Counsel has produced before us the list showing the particulars of all those head constables whose names were brought in list D, the promotional list, for promotion to the rank of ASI with effect from December 21, 1966 and thereafter up to February 18, 1970. He has also produced another list showing the particulars of ASI whose names were brought on list E, promotional list, for promotion to the rank of SI is drawn on July 21, 1978 and thereafter up to August 14, 1985. We have perused the lists and given our anxious consideration to the question urged. We fail to understand how the appellant could be ranked above his seniors and how he could get flyover promotions in every cadre. The High Court, while directing confirmation of the appellant with reference to a particular date, did not say that he should be ranked above even those who were appointed earlier to him. There was also no direction that he should be ranked above those who were liable to be confirmed before him. Indeed, it was not the intention of the High Court and it could not have been intended to, since his seniors were not parties to the writ petition. But the faulty implementation of the order of the High Court has resulted in that undesirable consequence. It has resulted in suppression of appellant's seniors. In fact, the appellant has overtaken 21 SIs who were senior to him. That was totally unjustified and arbitrary. In service, there could be only one norm for confirmation or promotion of persons belonging to the same cadre. No junior shall be confirmed or promoted without considering the case of his senior. Any deviation from this principle will have demoralizing effect in service apart from being contrary to Article 16(1) of the Constitution. It is not shown that the seniors were not eligible for confirmation when the appellant was confirmed, nor it is shown that the seniors were not suitable for promotion when the appellant was promoted. The appellant therefore could not complain against the corrective action taken by the respondents. In the result, I want to narrate one more event. For those FDAs who had two promotional posts available, I'm instructed, my lords, that an option was actually given to both all those such candidates who are FDAs. They can choose either of the two posts. Had these employees like the petitioners knew that choosing the post of senior assistant for their next promotional avenue could give them an order earlier than those who are choosing for the post of
There is no
ACOs.
such this thing.
There are, my lords. Otherwise, there is how could the employer generally choose employees to be fitting into the next promotional post of either senior assistant or the post of ACO? How will that happen unless a consent is
Yes.
required?
For that, choosing there should be a consent.
Yes. Now, my lords, how if the choice is given on a singular day,
avenues available for promotion, they will give an option. Whichever they want, they will take an options and they will.
Now, this will not be this option is given on the day when both the posts are made available.
Yes.
And candidates to whom this option is made available to is sought for, those candidates are already the ones whose promotions will be considered on the same day. So if today there are two persons who are given the choice saying that you can choose either to be promoted as senior assistant or ACO, then my lords, that is the day when they are both entitled for consideration equally on the same day. So they give the choice only that day. Now, after taking the choice on that one day, if one file is processed earlier than the other file, the impact of that is a demoralizing impact of making a senior junior to other person. This should not be, conditionally, this should not happen in an institution of this high. Nothing beyond that I can say. The arguments, technical arguments
No,
are.
Are there any reply giving that why that delay in signing that?
Nothing. We are not even made aware when the orders are signed. We were all the employees are under the sweet assumption that when the file is.
Any judgment you have, promotion cannot be implemented without the seniority list.
I will read the rules itself. Should there be a rule which requires the employer to not have a seniority list and still assume that somebody is senior to the other?
No, therefore, is it any judgment which says
I
that
will-
it's must?
I will
Because
not.
otherwise that employee will not know that, see, there is a seniority list, then provisional seniority list has to be issued, objection has to be
Yes.
called for, then seniority list, then implementation.
Yes.
Can it be bypassed and do it? That is not any judgment on that.
I will make that available, my lord. But my lords, I have other material produced here. Kindly see the orders at Annexure E series, which starts from page 36.
Yes.
Annexure E, page 36. My lord, this is the promotion given to the senior assistants to officiate as section officers under local cadre. Signed on 16/8/2023. Kindly see the signature.
Yes.
Then, my lords, the next page, 38.
Yes.
This is also promotions to the senior assistants to officiate as section officers. This is also signed on 16/8.
Yes.
Then page number 40. Assistant court officers to officiate as court secretaries, Group B. All these posts are Group B.
Yes.
So two different posts are filled up, which fall in one cadre, signed on 16/8/2023.
Yes.
The next one at page 42, assistant librarian to officiate as Group B, deputy librarian, from Group C to Group B,
Yes.
signed on 16/8/23. Then senior assistant to court officer, signed on 16/8/23.
Yes.
Now, the norm in the High Court seems to be that probably this is kept in mind that two persons from two different feeder cadres are, if they are promoted, and
No, it should be same. Otherwise, it
that's
will
why it is
affect
signed
that
on
next promotion.
That's promoted. That's why they are all signed on one date, 16/8/2020. I'm just giving one example.
Yes.
I cannot, not being a part of this high institution, I cannot point out any anomalies as such.
Yes.
But what I can point out is how the norm has been, and why not the same norm in the case of the petitioner vis-a-vis the respondent number 3. That's the only small murmur I can make. I cannot make a
Yes.
stronger objection to this one other than that. But the impact is entry in this entry in the High Court is 10 months earlier, prior to the entry of the respondent number 3. And once I hold the qualification earlier to the respondent number 3 as a law graduate. All the efficiencies that I have shown during the entire period, including my seniority, has been given a go by just because of one small mistake, which could be only, nobody would have even understood that signing these two orders on different dates could have some impact on the seniority or anything. It is signed on a different date. Therefore, my respectful submission is, I will also supply, my lords, I will make some research and supply whether in the absence of a particular specific provision, the requirement of a combined seniority list, publication of that and calling objections is mandatory or not. Nonetheless, my lords, my other submission is that merely because the orders are signed on a different date, but the consents are obtained on one date from both the candidates, that is the date when they become entitled for promotion, for being considered for promotion, if not for entitlement. Then once if they are taken the consent on the same day, whether mere signing, which is just a ministerial act in this case, I may say, it is not that they have the application of mine was lacking on the earlier date. The files come on different dates with so much of work before the authorities. So just because the files have come on a different date, signing would that impact the length of service in that feeder cadre? Should not that portion of the provision showing that length of the feeder cadres, that how should it be understood in the facts of this case is one which your lordships may accordingly consider.
Yes.
I will also produce, my lords, if given some time, I will produce the relevant judgments which will satisfy your lordships as to the requirement of a seniority list, and I reserve my right to reply.
The controversy lies in an extremely narrow position. Right? You take the statement of objections. Yes. Again, the service particulars. Yes. At page 4. My relevant is more or less accurately not stated. Yes. The relevant criteria, what we need to bear in mind is that in the one promotion prior to this post, what did they become? One of them will not become the first division assistant,
Another becomes an assistant court officer.
Hmm.
Now, these two are different positions, as I showed on the rules. Your Lordship, we go to page 5 now.
I think there is some mistake, if I'm sorry. One of them doesn't become ACO, the other becomes FDA. One of them becomes senior assistant, the other becomes ACO.
I stand corrected.
Yes.
Page 5, para 10.
Yes.
The relevant rules with regard to promotion to the post of assistant court officer and senior assistant, as per High Court of Karnataka rules, is as under assistant court officer. By promotion on the basis of seniority come merit from the cadre of first division assistant, audit clerk, accountants, who possess degree in law from a recognized university, provided that they have completed 2 years of satisfactory service in the field case. No eligible candidate is available, then not as an exception, I can skip that. Then senior assistant. 25% of the vacancies to be filled up by promoting the first division assistant, audit clerk, accountants working in the High Court, having degree from university established by law in India, provided they have completed 2 years of satisfactory service in the field. So the first para of the two are identical, except that in the case of senior assistant, it's only 25% which can be filled up by this manner.
Yes.
The remaining 75% will be filled up by promoting from the lower levels.
Yes.
So, my lord, the degree in law is common to both.
Yes.
Now, my lord, what happened in this case was that the third respondent opted for this assistant court officer's position, senior assistant position.
Yes.
Whereas the petitioner opted for the assistant court officer's position.
Yes.
Now, Lord, if I may continue reading, Lord, at bottom of page 5,
Yes.
para 11. The sanctioned post of court officer under the local cadre are 5 posts. During the relevant time, the working strength was 4, and 1 post had fallen vacant due to the promotion of Srimati N.R. Geeta, court officer as assistant registrar. As such, the office of respondent number 1, as per the rules and the method of recruitment to the cadre of court officer, considered for promotion to the post of court officer from the eligible officials from the feeder cadres, namely assistant court officer and senior assistant. So the date on which, my lord, the post became vacant of court officer, a selection had to be made, an appointment, promotion had to be made.
Yes.
At that juncture, Lord, the rules provide how it should be done. And the proviso, my lord, you have extracted next paragraph.
Yes.
Here. How promotion is, by promotion on the basis of seniority come merit, from the cadres of assistant court officer and senior assistant, who are law graduates, seniority being reckoned on the basis of the length of service in the feeder cadre, provided that they have completed 2 years of service. So the feeder cadre is defined here. There are 2 posts, assistant, senior assistant, and assistant court officer. Both these are feeder cadres. So you have to put them together. So when you put them together, the third respondent has few days seniority over the petitioner. Now, not they're trying to say that it was some signature, this, that. That happened in 2021. If your lordship should see, Malaric faintly tried to say that this was because they were not aware and all that. Kindly take this petition, my lord. They have produced both these orders, annexure C at page 31. They can't say now that they were not aware, is that. Annexure C, my lord, is the order of 14th June 21. Promoting the petitioner.
Yes.
The lordship should see them, right? Next is the court under so and so. The Chief Justice is pleased to promote the following first division assistant to officiate as the assistant court officer group C in the local cadre. And their first name is hers.
Yes.
Then, Lord, kindly turn 2 pages later. Annexure D at page 33. This is, my lord, in exercise of powers conferred under Rule 7, as amended from time to time. Honorable Chief Justice pleased to promote the following first division assistant to officiate a senior assistant group C and the local cadre in the pay scale of so and so. Pay scale, everything is the same.
Yes.
7. There, my lord, your lordship will get at serial number 9. Manjunatha Siddhappa.
Yes.
This is third respondent. And this is, my lord, signed on 9/6. So, for whatever reason, these promotions to these 2 different posts, they had to follow a certain regime because your lordship saw the rule required that 75-25 to be applied in one case, All that had to be applied. That is applied. And they are promoted in 2021 to those respective posts. To now say, my lord, they have produced these documents, so apparently, my lord, they are aware. It's not as though, my lord, Kalburgi court has got some 1,000 officers, you are not aware.
Yes.
They are working together, they are in the same office, and there are only 4 court officers there.
No, he need not challenge, but he can say, my promotion should be from the date of my junior.
No, what I am submitting not is this. That also he did not challenge.
Now his prior is B is there.
No, prayer B, that's what I'm saying. Prayer B is like a backdoor prayer that is being made. If this challenge was there to this promotion,
Yes.
this has happened in 2021.
Yes.
3 years they kept quiet.
Yes.
No, my lord, delay, my lord, is something which is fatal if he wants to press his argument that the 2021 was illegal. Nothing prevented him from challenging it at that stage. But why did they keep quiet? And they also knew, my lord, the rule that the common feeder cadre for both these is here. It's not as though they are not aware, my lord. All government servants, my lord, they are watching the positions very carefully.
Yes.
What is my right under the rule? When am I going to get promotion? When am I going to get an increment? When will I retire? All these are not day-to-day things which people know about. So to say now that from 2021, June 2021 till April 2024,
Yes.
I made no attempt to at least even challenge it by representation. Nothing is done. And she keeps quiet. Now, my lord, if you strictly read the rule says that you have to take this as a common feeder cadre. So if you take the common feeder cadre, the respondent is more senior to the petitioner. That's the only answer, my lord, that we are given in the statement of objection. If your lordship would, my lord, permit me to continue reading statement of objection, paragraph, page number 6.
Now that court officer post has been given to the third respondent.
Yes, he is functioning now.
Yes.
Now the prayer is you remove him and give me that position.
No, I am not saying remove him. I am
No,
saying
that
there are
if it is
other
succeeded, he can say from the date third respondent has been given, all benefit has to be given to you.
only that.
That is the law.
Now, my lords, now if there are certain posts of court officers available in that local cadre, and both of them can be accommodated in that. I am speaking.
If she is eligible today, we consider.
And benefits be given from the day when that junior in the.
That we will see that first if their posters are vacant, now you can be considered.
That will satisfy your lordships. May if your lordships can call for those details and look into that.
He will get an instruction.
And my lords, one more request. If your lordships can also, if he can get the details, the orders are the signing authority is the honorable registrar. He signs it on different dates, obviously.
That's
whether the file was processed on the same day of the petitioner and respondent number 3 respectively or not, whether that also can have some bearing on my right. That's it.
No, see, in respect of that promotion is concerned, he can get it if there is any vacancies is there. You are eligible now, he can be promoted. In regarding that monetary benefit, still your client wants to insist, then we will see that records and all, it is necessary.
Yes.
He is agreed that if promotion is given, yes, I will.
Yes.
Then all this is not necessary. That can be done. Otherwise, I will go all these records and all.
That will, I think that
from the date of that promotion is entitled or that promotion which is given right or wrong, will consider.
It is only, my lords, to avoid a kind of an embarrassment to a senior person to now work under the junior. That's the only probably the requirement.
Now they are taking the defense that let us see that otherwise signing that this thing, if you allowed this to do it, then anybody's rights can be denied by signing 2 days delay.
No, but if it's a RFID action, it will go.
No, that will see that records and all. I'm not
But,
entering that.
What we do as parents is we name our kids starting with A so that they get the roll number as 1. There is no mala-fides here, but there is a design.
That's not pleaded also.
My lords, how can I plead? Must kindly see the first paragraph in the statement. They are saying writ should not be entertained because it's a high constitutional functionary. Can I not have restraint on my
Now let
complaints?
us see that if he's
Serious statement is being made that deliberately some was signed later.
no, that will call for the records why there is a delay. it is delay, they are entitled in that legally, then it's otherwise we'll consider all this.
I am not saying there is deliberate this kind of a complaint. I use the word murmur. I am only able to whisper, not even murmur.
Maybe all these consequences they are not thought, that the file which has been placed before them, they will send it. Now that they are taking that benefit and doing that. Now see, now rule says that this is what that has to be.
3 years later, because the perceived difference is there, that's how they come to court.
Yes. Next week.
Some date, if it is fixed, I can come on. There is some difficulty for the culprit bench to log in online and then.
Oh, that's
so
right.
in the
no,
week,
I said that. See, all roster for this is to be. There is no difference for Dharwad and Kalburgi. I said that should be in the same list. They can log in. Then they said that no, this is the problem.
Sometimes what happens in the vConsole, I don't know where we can make this clarification. In vConsole, when I log in, if I have to make a mention once, now there is a possibility. Suppose there is an end of the list matter moved, and I am a caveator. If I have to log in, there is no choice given there. I don't have an option to. It has to be created by the court officer probably on the same day itself. If there is an end of the list
matter which is in the list, they have been given others.
And sometimes what happens is
that will,
if the presiding officer is little faster in making the.
No, if that the end of the list it is moved, once the list is prepared, I think they will make that provision.
It has not. And sometimes what happens was the list will go faster from 15 to 20, 15 adjourned, 16 adjourned. We are at somewhere around 19. The court officers will not get time to, I don't know if they have to manually do it, to admit each person.
Unless they are permitted to log in, you can't.
We can't. If I am say at serial number 17 and if your lordship is like taking the files and giving it back at a little faster speed, they will not have time to switch from 15, 16, 17 and permit each of them. They will have to first attend to your lordships. And there we miss our chance.
Yes, we'll see. Yes. Yes, any day, Mr.
25th, is it possible?
27th, Friday? Yes. 27th.
Could it be on 25th if it is not?
27th.
Here I am coming here physically. If you can accommodate, yes. 27th. Fridays will be a little difficult, because I am aware the pressure will be different. Any day other than the Fridays for your lordships only.
No, but for me there is no problem. Then they're not sitting any other combination on the Friday. That is yes.
Great.
Serial number 2, Mahesh Patel.
Lord, appearing for the petitioner, Lord.
Yes.
Lord, here, Lord, I am seeking, Lord, the mandamus, Lord, directions to the responsible to consider the representation. Lord, the petitioner, Lord, is, Lord, the wife of, Lord, late one Baswantrai, Lord. He was in, Lord, court employee working as SDA. Lord, in the 5th respondent to court, Lord, in the 5th respondent to Lord at JMT. And Lord, he died, Lord, while in service, Lord. That is, Lord, the Lord, death certificate, Lord, is at page 11, Major A.
Yes.
A. And Lord,
Mr. Mahesh,
please.
You just wait. I will ask him to that given a facts, because it is not clear from your side.
Please.
Let him given a facts. Then I will ask you that what is that legal point.
Please.
What is
Lords, what has happened is, my lords, the petitioner is the wife of the employee, my lords, who died in harness.
Yes. No, it's a compassionate appointment.
No, my lords. It's for the family pension, my lords.
Yes.
Lords, the employee, my lords, expired on 14/12/2003, my lords. His name is Baswana Ratta.
Yes.
Lords, his 14/12/2003, my lords.
Yes.
While in service, he expired, my lords.
Yes.
Lords, based on the entries which he had made nominations, my lords, his daughter was given the benefits, my lords, of pensioner benefits and others at Annexure C, my lords, which is available at Annexure C, page number.
In service records,
Please, my lords. Daughter's name was there, my lords.
Yes.
Page number 15, my lords, Annexure C, my lords will get the details.
Yes.
Of what was the amount sanctioned, my lords, to the daughter.
Yes.
Later on, my lords, next annexure, my lords, Annexure D, my lords, he said it is Shakuntala and the daughter, wife and daughter have filed a P&SC case, my lords,
Yes.
for the family pension benefits, my lords.
Yes.
That is allowed
Yes.
by the Honorable Court, my lords, giving a succession certificate, my lords.
To both.
Both, my lords, at page number 26, my lords.
Yes.
saying that they are entitled for the family pension, page 26, my lords.
Yes.
They are entitled for family pension from that day and other benefits, my lords, is what the order is made.
Yes.
Later on, my lords, these order other things have been communicated, my lords,
Yes.
to the authorities.
Yes.
Even these answering respondents, my lords, they have also forwarded to the Accountant General Office, my lords. But then also they have not granted. Later on, petitioner has made a representation at Annexure M, my lords, pointing out these facts. Annexure M, my lords,
Yes.
to the Accountant General Office, my lords. At page number 48, I believe, my lords.
Yes.
Sorry, it's 40, my lords.
Yes.
Through proper channel, they have given the representation. My lords, asking for that records may be seen and steps may be taken for granting pensioner benefit at page number 42.
Yes.
Now they are seeking for consideration of this representation by the Accountant General Office, my lords.
No,
That's
so
the
far family pension is not yet fixed.
No, it was fixed and given to the daughter earlier.
That has not been now that family pension is paying to the daughter, or
It was being paid to the daughter. Wife is saying after this P&SC proceedings,
she is entitled.
She is entitled. She should be given because of the P&SC succession certificate which is issued, my
Now
lords.
who is appearing for this?
It should be government, my lords.
Yes.
They have to consider, my lords. From our side, it's not. There is no dispute.
Who is appearing for that?
It is the respond number 3, my lords, is to.
Yes, you consider that representation on the basis of that. That's all, Mr. Mantesh.
My lord, I thank my lord, the counsel, my lord, he has argued my case, and that my lord, one which I want to, my lord,
Yes,
add,
in
add
addition,
to that.
now it is clear. Yes, tell me.
Yes, my lord, here, my lord, since my lord, earlier she was minor, my lord, my daughter was minor. My lord, I consented, my lord, paying family pension to her. Now she has turned major, my lord. And now, my lord, there is no dispute whatsoever. And even there are correspondence between all the respondents, my lord, amongst themselves, my lord, to disburse me the family pension, which is, my lord,
No, family pension is paying to the daughter.
No, now it is not been paid to anybody, my lord. Now,
not been paid to anybody.
At that time, she was minor, my lords.
Now she is not entitled.
She will not be entitled. That's why mother is saying,
in
view of this, pay it to me.
Yes, yes, that should be their yes. Yes.
I'm entitled, my lord, and my lord, so I'm seeking, my lord. There have been correspondences. They will not deny that. And my lord, let them, my lord, grant me, my lord, family pension, my lord, and with all those arrears and all.
Yes, yes, we'll direct them to consider your representation. Yes.
My lord, mere direction may not suffice, my lord. Some, my lord, if
no,
some concrete.
That's what I have to. I can't give any positive directions. We don't know what is there in that. Then they will see the records. If they anything they are given an adverse endorsement, then we can examine that.
But so here, my lord. But here, my lord, there have been correspondences, my lord, and that, my lord, family pension has to be sanctioned to me. There are, and they are not denying that, my lord. The correspondence.
Let us see if they may grant. Why do you anticipate that they will not do it? If they are rejected, I will fix the time limit. Then yes, in this writ petition. Petitioner sought, who is appearing? Madam, you are appearing. Yes. What is your instruction, madam?
My lords, I have not received instruction so far. Acknowledgement is not forthcoming for having received this representation.
We will direct that AG office to consider.
Please.
Yes. In this writ petition, petitioner sought following relief. Annexure M is given to that AG office only.
Please,
not
please.
for
yes.
Not for that.
Yes, yes. Case of the petitioner that her husband, Sri Vaswanta Raya, was working in the office of fifth respondent. He was working as what, Mr.?
Second division assistant. SDA.
You are working as an SDA. While he was in service, he died on 14/12/2003. In the service records, of the husband of the petitioner, name of his children, and the petitioners was shown as a nominee for the family pension in the service register. Void annexure C dated 4/10/2013. The DCRJ of rupees 1,24,800 has been paid in favor of the daughter.
ಹೌದು
Daughter.
ಅಲ್ಲೇ ಇದೆ ಮೇಲೆ ಫೈನಲೈಸೇಷನ್ ಆಫ್ ಪೆನ್ಷನ್ ಕ್ಲೇಮ್.
Yes, and family pension has been sanctioned
2430 ಸರ್. ಅಲ್ಲೇ ನೆಕ್ಸ್ಟ್ ಲೈನ್ ಅಲ್ಲಿ
2430 in favor of
ಡಾಟರ್.
PM from the convert till death or remarriage, whichever is earlier ಅಂತ ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲ ಅವ್ರು ಆತರ ಹಾಕಿದ್ದಾರೆ, ಏನಾದ್ರು ಮದ್ವೆ ಆದ್ರೆ ಏನಾದ್ರು ಅಂತ ಹೇಳಿ ಆತರ ಯೂಶಲಿ ಹಾಕ್ತಾರೆ. ಇಟ್ಸ್ ಅ ಫಾರ್ಮ್ಯಾಟ್ ಮೆಲೋಸ್.
No, then even she is become major, she is entitled.
ಯಾವುದು? She will not be entitled now ಅಂತ ಹೇಳಿ. She is no more dependent ಅಂತ ಹೇಳಿ. Because of the majority, then she was minor.
Is it that law that after major she is not entitled ಅಂತ ಹೇಳ್ಬಿಟ್ಟು? ಏನು ಇದ್ದಂಗಿಲ್ಲ. ಇಲ್ಲಿ ನೀವು ಆಗಿರೋ ಪ್ರಕಾರ ನೋಡಿದ್ರೆ you have to be, there is no dispute for them. They are no dispute to give it to that. You are not paying anybody.
It was been paid. ಈ P&S ನಲ್ಲಿ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಫ್ಯಾಮಿಲಿ ಪೆನ್ಷನ್
it was
wife is entitled.
granted in favor of the daughter. In the meantime, petitioner and her daughter both has filed a P&SC petition before civil judge JMFC at Sedam in P&SC 1 of 2017 by order dated 24th April 2018. The succession certificate has been granted to that petitioner and her daughter. Thereafter, petitioner has submitted a representation by annexure
M, my lords.
Annexure M
At page number 40, my lords.
Submitted to that respondent number 2.
Respondent 3, my lords.
Respondent number 3. Seeking granting of family pension in favor of the petitioner. After that, her daughter become major. They're not paying any family pension. So far, no action has been taken pursuant to that annexure M. Therefore, petitioner before this court. Learned government advocate appearing for respondent number 3 submitted that if this court grants some reasonable time, the representation submitted by the petitioner by the annexure M will be considered in accordance with law. Annexure M dated 30th/5/2024. In view of the above, without expressing any opinion on the merit of the case, the third respondent is directed to consider that representation submitted by the petitioner by the annexure M dated 30th/5/2024 as expeditiously as possible, not later than 3 months from date of receipt of copy of this order. Yes. Yes, Mr. Patil. Mute ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
Yes, but respond number 5, my lord. Let there be directions to respond number 5 also, my lord.
No, that AG office has to do it.
We have forwarded it, my lords.
ಇಲ್ಲ,
We have
ಮಾಡಿದ್ದಾರೆ.
forwarded.
They have forwarded. Your representation is only an annexure M to that accountant general office.
ಇಲ್ಲ,
They
ಎಲ್ಲಿ
have to
ಇದೆ?
pay the
ಇಲ್ಲ,
pension, my lords. We
ಇದ್ರಲ್ಲಿ
don't
ಇದೆ.
have anything.
ಇದ್ರಲ್ಲಿ ಇದೆ, ಮೊದಲು ಇದ್ರಲ್ಲೂ ಇದೆ. Page K 37, page 37.
ಅವ್ರೇನ್ ಮಾಡ್ತಾರೆ? ಅವರು they are not doing anything.
But my lord, if my lord, they communicate my lord, the orders my lord of this honorable court my lord to the AG, they will certainly do it my lord.
No, that government advocate is
Yes, sir.
communicating. They are there. They are representing. Yes.
Please,
Yes. Within 3 months, they have to be considered. Yes.
please.
Huh? No, that she is also government advocate. She is appearing. It's Senio from Dharwad. Lydia. Viran M. What's your name, madam?
Maya TR, HCGP, my lord. I have logged in.
Maya?
Maya TR.
Maya TR. Yes.
Much appreciated.
Passed over matter.
Yes.
Passed over matter. Serial number 4. Krishnadas Rai.
Yes.
Respondent number 1 and 2 in this matter.
Yes, all this covered by same this thing, madam.
My lords, I have just received the copy today. We are yet to receive wakalat from the respondents.
Is it covered? There is no this thing.
My lords I have not been able to go through the,
Yes. What you say about that serial number 64?
both 64, 65 and the present matters, all of those are covered.
64, 65, you have not yet get the instruction.
No, my lords.
That it has been.
I seek 2 weeks time to get the wakalat as well as instructions.
No, you get it's all covered by decision. We'll fix the date on that day. You get that instruction.
Please.
Yes, serial number. Avrdu Krishnadas Rai idiyalla adralli elladrallu so and so is directed to take notice. Counsel for the petitioner is directed to serve one set of copies. Read this matter on 30th.
One more submission. 65 I am not appearing. In some other person. Only 64 I am appearing.
60?
64.
65 ಇಲ್ಲ ಬರೀ 64 ಮಾತ್ರ. Director of Managing Director ಅದು ನಿಮ್ದೇನಾ? ಅದು ನಿಮ್ದೇ ಅಲ್ಲ?
65 as well.
Sir,
ಆಯ್ತು, ಸೇಮ್ ಮ್ಯಾಟರ್
Similar matter.
ಆಯ್ತು 64, 65 ಇವು ಎಲ್ಲವೂ ಕನೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು post this matter on 30th.
Yes.
Get instruction on that time.
One more writ petition. It was heard on 12th. I think that is not listed actually.
ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಅದು ಆಕ್ಚುಲಿ 12th ಗೆ ಬಂದಿತ್ತು. ಅವತ್ತು ಐ ಥಿಂಕ್ ಅಡ್ವೊಕೇಟ್ ಇದು ಬಂದಿಲ್ಲ.
ಆಯ್ತು, ನಾಳೆ ಬರ್ಲಿ ಅದು ಕೋರ್ಟ್ ಮುಂದೆ ಪೋಸ್ಟ್ ಆಗ್ಲಿ. ಮೆಮೊ ಕೊಡಿ, ಪೋಸ್ಟಿಂಗ್ ಫಾರ್.
ಅಲ್ಲ 12th ಗೆ ಬಂದಿತ್ತು, ಬಟ್ ಇವಾಗ ಡೇಟ್ ಕೊಡ್ಲಿಲ್ಲ ಅದರಲ್ಲಿ ಪುನಃ. 12th ಗೆ ಲಿಸ್ಟ್ ಆಗಿತ್ತು.
ಏನಾಯ್ತು ಅದ್ರಲ್ಲಿ?
ಅಲ್ಲಿ ನೋಟಿಸ್ ಅಂತ ಬಂದಿದೆ ಅಷ್ಟೇ, ಬಟ್ ಡೇಟ್ ಕೊಡ್ಲಿಲ್ಲ. Actually, I have served.
Let us see. You will on that day.
In that case, the daily order says that it be connected with other matters and.
But connect actually ಇಪ್ಪ ಪುನಃ ಲಿಸ್ಟ್ ಆಗಿದೆ. ಕನೆಕ್ಟೆಡ್ ಅಂತ ಬಂದಿತ್ತು, ಬಟ್ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆ.
ಅದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದ್ರೆ ಮಾಡ್ತಾರೆ. Let us see. Otherwise, you will post this matter next day after disposal of. Yes. All matters. Yes.
Serial number 19. Ravindranath K.
Yes.
Lords, 18 and Lord, your lordship is granted the interim order. Similar matter, Lord, where my case is also 19.
What is that?
Under 19. 19. Lord, one second. File.
Day after tomorrow.
No, file is here. Lord, similar matter, my lord, where your lordship has granted, say 18, my lord. Show cause notice which has been issued. by the Lord Bescom authority. Lord 18, Lord serial number 18, same squarely Lord, applies in my
Now,
case.
what is that 18? What is that? Here something charge memo and all is been issued.
Lord, no. Same thing, Lord. I will, Lord, kindly see them, Lord, prayer annexures. Lord, there, Lord, the after Lord 10 years, the Lord, the committee report which has been Lord published, saying that Lord, the mass card which has been Lord sent, it is not genuine. So on the basis of that, Lord, show cause notice has been issued. Same show cause notice which has been challenged, Lord, identical matters, where your lordship, Lord, the serial number 18 was also granted.
Same matter, Mr. Government Advocate. Have you seen that?
Same matter, same questions, my lord. There also, my lord, show cause notice which has been challenged, issued by the authority.
ಅದು ಫೈಲ್ ತರಿಸಿ ಅದು ಫೈಲ್ ತರಿಸಿ ಆರ್ಡರ್ ಇದೆ ವೆದರ್ ಇಟ್ಸ್ ಎ ಸಿಮಿಲರ್ ವಿ ಡೋಂಟ್ ನೋ ದಟ್
Government is also party.
ಆಯ್ತು ಅದು ಒಂದು ಫೈಲ್ ತರಿಸಿ ವಿಲ್ ಸಿ ಪಾಸ್
18, serial number 18.
yes we'll see if it is similar then we'll pass same order yes
Even 14, 15, 16, Lord, and where
ಅವ್ರದ್ದು ಸಿಮಿಲರ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಿದ್ರು ನಿಮ್ದು ಅದು ಸಿಮಿಲರ್ ಅನ್ನೋದು
similar.
ಅಂತ ನೀವು ನಾನು
Please.
ನೋಡ್ಬೇಕಲ್ಲ
Please.
ಯಾಕಂದ್ರೆ ನಿಮಗೆ ಡೌಟ್ ನಿಮ್ಮ ಹತ್ರನೇ ಫೈಲ್ ಇರ್ಲಿಲ್ಲ ಎಲ್ಲ ಮಿಕ್ಸ್ ಅಪ್ ಇದೆ ಡೋಂಟ್ ಅಗೇನ್ ದಟ್ ಮೇಕ್ ಇಟ್ yes
Serial number 23. Vivekananda?
Yes, my
yes
my lord, in this case, we did the compliance, my lord, that registry has to see this one because it's a annexure D, just we couldn't file that certificate copy. For that only, we filed that
Yes.
dispense with application.
Learned counsel
Kindly have it on day after tomorrow, my lord.
and learned counsel for the petitioner submits that office objection has been complied.
Yes, my lord.
Office to verify and post this matter day after tomorrow.
Yes, obligation.
Serial number 24. Narsim Raju?
Objections are complied.
Complied ಐತೆ
Only pagination only, not
Detailed
alternative prayer relief was not mentioned.
pagination is made properly
That I have done.
full done yes
That petitioner is a bill collector, group C, my lord. He was regularized, my lord, by virtue of order of regulation dated, my lord, 25/6/2020, page 16, my lord, for a moment. Page 16. Serial number 3, my lord, Gopalappa,
yes
was regularized and posted to, my lord, Pattana Panchayati Bashettiali.
ಪಟ್ಟಣ ಪಂಚಾಯತಿ ಎಲ್ಲಿದೆ ಅದು
Pattana Panchayati Bashettiali. Lord, kindly come to next, my lord, next. I reported there, page 21.
page 20
21. I reported there on 21, 28/6/2024, before the chief officer. I reported there.
yes
But not group C, it's a post group C, my lord. Minimum tenure is 4 years as per the transfer guidelines. Transfer guidelines are produced at page number 27. 27, page 30 is the relevant portion, my lord. Page 30, group C, my lord, 4 years.
yes
But I have been disturbed, but without posting, kindly come to page 13, annexure A, my lord. Page 14 is the relevant portion. Fifth respondent posted to my place. I have not given any posting. Page 14, my lord. Page 13 is the transfer of annexure A. Page 14 relevant portion. Srinivasa has been posted to my place. I have not been shown any place, any placement.
ಸ್ವಂತ yes certificate ಪಂಚಾಯತ್
Gopalappa, there is no posting as such.
Yes,
Contrary
Mr.
to SEMA case, my lord, also, my lord,
25 ಹೆಸರಿನ ಮುಂದೆ ಅಂಬೇಡ್ಕರ್
SEMA case violation, and principal secretary, chief secretary himself, herself, not has directed not to effect the transfer without any posting.
yes
That Tiffany also produced before lordship.
issue notice government advocate is directed to take notice for respondents 1 to 4
1 to 4, my lord,
ಅಲ್ಲ ಚೀಫ್ ಆಫೀಸರ್ ಬೇರೆ ಇದಾರಲ್ಲ
chief officer.
1 to 3 counsel for the petitioner is directed to serve 2 sets of copies on government advocate issue emergent notice to 4 and 5
Please.
stay of annexure A in respect of item number 10 related to the petitioner and respondent number 5
5 minutes.
till next date of
For hand delivery.
yes
Please.
Serial number 26. Ravindranath K.
Yes.
Consideration of interest rate for Mr.
Yes, yes, yes.
Office objection is complained, Lord. Again, it is.
Yes.
Yesterday only I complained.
Yes.
Maybe over.
Yes. No, yes, Mr.
Lord, I saw the other petition. They are on very similar grounds.
Yes.
My only request, my lord, is that, my lord, these petitions have been pending since, my lord, the issue has been pending since 2015. And their employment has been only based on, my lord, one or the other writ proceedings. Therefore, my lord, my request, my lord, is I have to, my lord, rely only on the order that has been passed, show cause notice order, my lord. I cannot improve the case. Lord, therefore, my lord, at this stage itself, my lord, my request is to hear the matter on any day. My lord, I will not take more than half an hour, my lord, and decide the matter one way or the other. So that, my lord, if the order has to go and I have to re-exercise 11A.
See, if it is order which is not in consonance with that regulation, you can redo it.
I can redo it, my lord. Therefore,
but that so many other matters is there. You give a list. One day we'll decide whether you have passed an order in terms of that your regulations or not.
Yes.
They will consider and dispose
But
of.
instead of, my lord, once the interim order is granted, it will become like this, my lord. It will keep, be pending for a very long time.
We can't deny only this batch. We'll say any date. See, only thing is that if there is any material available on the report saying that you can come to the conclusion and impose the penalty, you can do it. Otherwise, you have to do it redo. That is what the rule says.
Yes, my lord.
If all the findings is in their favor, you can't say that imposing the penalty. You can say, no, this inquiry is not proper. Therefore, I want to redo it or de novo inquiry. You can appoint anybody else. You can do it. That is what the rules prima facie says.
Correct, my lord.
Subject to how you are convincing.
I possibly will be able to demonstrate, my lord, that 11A exercise has been done properly.
No, exercise can be done.
It's been done properly.
It's two options. One is that inquiry reports, all finding is against them. Still that inquiry officer is said that charges
So
are not.
here, my lord, the report is very cursory. Very cursory. The report of the inquiry officer is very cursory, but material which is available before the inquiry officer, which is placed before me, indicates, my lord, that it should have been the other way around. That is why the show cause notice. And, my lord, in cases, my lord, where
the inquiry officer report is cursory, because the inquiry officer's report is more detailed than perhaps what their.
No, it's, my lord, it has not.
No, that's
only on the ground.
They are entitled to do it. They are not happy with that inquiry officer.
No, there are documents which are, there are witnesses examined, documents are available, but he has gone on only one statement of one officer and comes to the conclusion, my lord, that I have not proved the document, ignoring what document they produce.
Yes, they will grant interim order and fix the date, give all numbers, will in all cases, this is the point. One of them has to be.
My lord, the problem is this, wherever the process had not been done, my lord, properly, we ourselves, my lord, considered, and those matters, my lord, were writ petitions were allowed, and we were directed to redo the process within 45 days. Here, what has happened, my lord, is in many of the matters, my lord, the exercise has been done properly, but it's a complete mix.
No, which is that judgment where earlier it is passed and they are expected to redo.
Yes,
I think
that also you had placed on the last.
26th April 2025, my lord. So the order where we considered, my lord, that there was a requirement to redo the process.
What is that defects in that?
Ali show cause notice did not disclose the reasons, grounds on which I would like to take a different view. But it requires that the show cause notice, Lord, discloses the ground on which I would like to take a different view.
Disciplinary authority, if it is not itself inquiry authority, may reason to be recorded writing in so. The disciplinary authority, if it is disagree with the finding of the inquiry authority on any articles of charges recorded in the reason for such disagree and record its own finding, the evidence on record is sufficient for that purpose. We have regarding such finding in all any of the articles of charges of his opinion that one or more of the In the rule should be that import of.
Para 11 on.
Shall be. Yes.
11 and 12, that's the only reasoning.
Hmm.
And the direction, my lord, is to redo it within 45 days.
12 is the
12.
point, my lord, the ground which was taken by the Learned Single Judge was
Hmm.
following the judgment, my lord, in the Kunju Bihari's case, Kunju Bihari Mishra's case. If you have to follow the procedure under 11A, you have to first tentatively record why you are disagreeing with the findings of the inquiry officer. Then you must give an opportunity to show him, for him to show cause, and then come to a conclusion and then impose the punishment. Whereas you cannot already have determined, even when you issue the show cause notice itself, I have determined that the inquiry report's finding is wrong, and then issue a notice, then that serves no purpose.
Same thing is happened in
Same
this
thing
case.
has happened in this case.
I will be able to show, my lord, that it may not be the same situation. Therefore.
In fact, I have got the show cause notices and termination orders passed in those cases also. I have got that.
Only difficulty is, my lord, each of these petitioners, there is a separate inquiry, separate report, separate show cause notice, and there is, apart from the fact that they are all issues where there are allegations of.
Give that all matters, we'll have it on 4th at 2:30. Then we'll dispose of all the matters on that point. Till then, now that we'll grant an interim order in respect of the cases which are pending. But some other cases also coming that.
ಅದು ಹಳೇದು.
ನಂದು ಇವತ್ತು ಯಾವ್ದೋ ಒಂದು 3-4 ಅದರಲ್ಲಿ ನೀವಿಲ್ವಾ ಅದರಲ್ಲಿ ಸೇಮ್ ಮಾಸ್ ಕಾರ್ಡ್
notice has been not today it has been ordered for
that your case
no not Suvarna not some
same ಕೇಸ್ಗಳ
that is only a show cause notice here termination order there it is only a show cause notice
ಅವು ಒಂದಷ್ಟು ಇದಾವಲ್ಲ ಏನದು
ಅಲ್ಲ show cause notice before replying to the show cause notice they have approached the court.
ಅಲ್ಲ ಅದರಲ್ಲೂ ಯಾವ್ದೋ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಎಲ್ಲ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಹಂಗಾಗಿ ಐ ಆಮ್ ಆಲ್ಸೋ ಗ್ರಾಂಟೆಡ್
that is what is but I think my learned friend has taken
said perhaps it is best that all of them be consolidated so that then
thing is not
that is different, that is where the inquiry itself is not completed. Here is the penalty has been imposed, therefore first we'll decide this, then other no batch ಮಾಡ್ಬಿಟ್ಟು we'll decide that also. There also I think every day they are taking in a step. You verify, you collect all this and
yes,
who is counsel appearing.
Almost my senior friend is only their office only.
I am appearing in one.
ಇವತ್ತು ಅವ್ರ ಲಿಸ್ಟಲ್ಲಿ ಅವ್ರ ಹೆಸರು ಯಾರು ಇಲ್ಲ
ಅಲ್ಲ because it is only a Bescom notice has been ordered by your lordship, that's all. They have not yet
Find out.
no Bescom ಗೆ ಅಡ್ವಾನ್ಸ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಬೇಕಂತ ಇಲ್ವಾ Bescom ಗೆ ಇಲ್ವಾ
it is served but they have not
nobody is represented, that's what, therefore we
14 15 16
ಇದು ಒಂದೇ ಮ್ಯಾಟರ್ ಇನ್ಯಾವ ಮ್ಯಾಟರ್ ಇದೆ this
it is my
my lord may take up this matter on the 4th, my lord. Once it becomes a batch, my lord, somebody or the other person will come and
you are
take
relying
time.
on that interim order granted by
Yes,
this court. It is also similar, that also
it is a Bescom, that is a Mescom.
Mescom, but
that is what WP 14056 of 20
company ಬೇರೆ. But I got a copy of the petition, my lord.
ಅದಕ್ಕೆ ನೀವು ಅಪಿಯರ್ ಆಗಲ್ವಾ
ಇಲ್ಲ,
PC Prabhakar is already appearing.
Subramanya appears, my lord, in that case.
but you are appearing in this case only.
ಹೌದು.
Then we'll decide this
Yes.
is, they are not moving anything, why should I take? They are not moving that matters to dispose of, you are even vacating that. Yes. Or you are taking notice to whom? All.
No, first is the government.
Government advocate is directed to take
2
notice.
to 10 my lord.
So and so is undertake to appear for 2 to 10. Learned senior counsel appearing for petitioner has submitted that in identical matter this court in, where is that order?
Not that your lordship.
Annexure F.
Page.
ಇಲ್ಲಿದೆ.
In WP my lord 14056 of 24
and 58
14058 of 2024
and 14056 both
yes, granted an interim order.
Can I pass this out
Until the next date of it, ensure that there is no precipitation. Yes.
detailed order?
In view of the above, respondent are directed not to proceed the matter till next date of hearing. This matter on board.
Lordship, see, my lord, in considering to ensure that there is no precedent, interim order as prayed for is granted to be enforced. Your Lordship, see the detailed order, and the interim order is which is extracted at the bottom. To stay the order is so and so, and direct to reinstate until this.
That interim order you are sought.
Same. Lord.
Yes, in view of the above,
As prayed for.
interim order as prayed for. This matter on 4th.
Lord, may I request
2:30.
5th.
Fifth, I will not say. Fifth is the short admission. Yes.
Sorry. I was saying the.
Yes.
Lord, the third, will may I request on third.
Friday, I think better we will have it 2:30 anta. Otherwise, Friday,
Only one.
there a matter.
Just one matter got posted now for 4th at 2:30. That's the only request. So third or Lord, seventh, subject to Lordship's.
Or next 14th.
No, that the third 2:30 will see.
Third.
Yes.
Grateful.
Yes. I think it will not take much.
Please.
Yes.
Lord, sorry, my lord, I got it. Sorry.
Still number 19.
Maybe the 18.
Lord, kindly see the show cause notice, Lord.
Hush, annexure E.
Prayer is also, my lord. Kindly see.
ಅಮಾನತುಗೊಳಿಸಲು ಆದೇಶ ಇಲ್ಲ. Suspension order. No, dismissal from the service.
No, it is not yet been done, my lord. It's only show cause.
ಕಾಯ್ದೆ ತಕ್ಷಣ ಜಾರಿಗೆ ಬರುವಂತೆ ಸೇವೆಯಿಂದ ಅಮಾನತುಗೊಳಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ. This is suspension order, Mr.
Please, my lord, that's all.
ನಿಮ್ ಕೇಸಲ್ಲಿ
Annexure, my lord, here show cause notice, ಅದರಲ್ಲಿ show cause notice challenge ಮಾಡಿದ್ರು.
No. Here order is they have already passed an order keeping under suspension.
Lord, even 14, 15, 16, similar, my lord. They may go into, my lord, that is also my intention is that, my lord, in the virtue of the, my lord, show cause notice, because kindly see the, my lord, order which has
No,
been
let
passed.
them pass an order, you give a
No,
reply here.
my lord, kindly see, my lord, Karnataka, annexure, my lord, J2, my lord, for a moment. J1, my lord, Lord, kindly see the, my lord, the Karnataka one Suchana Patradalli, Ullekadalli, my lord. Ullekadalli, my lord, this notice, my lord, they have requested to, my lord, give a report in the year, my lord, 2016. Kindly see the, my lord, the Ulleka Muru, my lord. Ulleka Muru.
Annexure J.
Annexure J, my lord. Ulleka, my lord, in that Ulleka Muru. Lord, these, my lord, respondents, my lord, authority sent a letter to the, my lord, the ITA board to at least give, my lord, in respect of the master which has been submitted by the, my lord, the petitioners, whether it is genuine or not, or it has been issued by the same authority. It is issued, my lord, 2016. Lord, kindly see, my lord, the report which has been submitted on Ulleka 4 only. Lord, that is on received on 13/5/2025. After, my lord, lapse of 11 years. Lord, at least opportunity which has not been given. Lord, this is the way, my lord, where Bescom, Lord, taking this order after issuing the, my lord, appointed in the 2015, Lord, sent on 2016 report which has been received on 2025. That too in the 3/5 mail. Similar issues, my lord, which has been granted by this.
In identical matter, this court, which is that matter you are relying on, that similar
Serial number 18 and 14, 15, 16 and 18.
court. ಇದರಲ್ಲಿ ಆರ್ಡರ್ ಇದೆ. ಇದರಲ್ಲಿ ಆರ್ಡರ್ ಇದೆ. Hence he sought for directing the respondent to not to terminate the service of the petitioner. Adal suspension is either termination. That is what the difference, Mr. That's why I said it is not in view of the above. The respondents are directed not to terminate the service of the petitioner on the basis of the show cause notice dated 21/5/2025 with annexure J till next date of hearing.
J1, 3 petition.
Annexure J1, J2.
Applies.
In respect of, otherwise they will not be terminated even if you committed anything else.
That's why, my lord, that is our issue, my lord, intention before this court.
Yes.
Applies.
Serial number 41.
Paper petitioner, my lord.
Shashidhar Agali.
Which one? 41.
Yes, my lord.
Wait. I have not read. What is this matter?
My lord, ತಾವು ಒಂದು 10 ನಿಮಿಷ ಕೊಟ್ರೆ I just want to brief in a nutshell, complete the facts basis on the documents available before the court, my lord.
I am not deciding Just tell me what is the fact.
This is the facts is I am seeking the promotional benefits, my lord, because I have retired, my lord.
Yes, you.
But the
Let us see whether he is ready. Unnecessary should not be. See, in
Ala,
which,
that is the reason, since he is seeking time, I just want to brief 10 minutes the facts basis on the documents available before the court. The once the documents not good, then I leave the discretion to the court, my lord.
Yes. Let us see what is the case that. Such a accommodation cannot be made. Let us see if there is an urgency. Otherwise, because that you are flying overseas, we cannot be granted for a month's together time. It is for the department to make alternate arrangement. If there is no urgency in this matter, I will grant time.
And just 10 minutes, my lord.
Yes.
My lord,
No,
just
1 week we can make it. Not that 2 months, 3 months. Yes. Yes, let us see that. Yes, which is the department?
Karnataka State Legal Service Authority.
You are appearing for Legal Service Authority. Yes.
My lord, I'll just take you directly to the page number 44, annexure H, my lord.
Because last occasion it was heard, you are not there.
Yeah, he was there, my lord. He was there. He said no objection.
Yes, yes. Let us see. Yes, what is that?
My lord, kindly see annexure H, my lord. Page 44. My lord, this is the proceedings of the 14th annual general body meeting. 44, page 44, annexure H.
Yes.
This is the Karnataka State Legal Service Authority, Bangalore, proceedings on the 14th AGM, my lord, held on 5th October 2005. My lord, kindly see page 47, my lord.
Yes.
Page 47.5, my lord. If you permit, I would read, my lord. To consider amendment to serial number 8 and 11 of Schedule 1 in the Karnataka State Legal Service Authorities Rules 1996, so as to provide promotional opportunities to the existing clerk cum typist to the post of assistant. This is the promotional to consider to give the promotional aspect to the clerk cum typist to the post of assistant. My lord, kindly see page annexure P, my lord, page 72. Page 72, my lord, annexure P.
Yes.
My lord, if you permit, I would like to read, my lord.
Yes.
This is from the R1, Sarkarada Pradhana Karyadarshi to R2, my lord. Subject, Karnataka Rajya Kanunu Sevagala Adhikarada Niyama 1996.
Page 72, P, annexure P.
Yes, my lord. I am reading the subject, my lord.
Yes.
Karnataka Rajya Kanunu Sevagala Pradhikara Niyama 1996 Schedule 1 ಕ್ರಮ ಸಂಖ್ಯೆ 8 ಮತ್ತು 11 ತಿದ್ದುಪಡಿ ಮಾಡುವ ಬಗ್ಗೆ. This is basis on the AGM what they have decided and serial number 1, my lord. ಕ್ರಮ ಸಂಖ್ಯೆ 8 ಸಹಾಯಕರ ಹುದ್ದೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪ್ರಾಧಿಕಾರದವರು ಪ್ರಸ್ತಾಪಿಸಿರುವ ತಿದ್ದುಪಡಿ ಮಟ್ಟಿಗೆ ಸರ್ಕಾರ ಮಟ್ಟದಲ್ಲಿ ಅಭ್ಯಂತರ ಇರುವುದಿಲ್ಲ. This means what is the recommendation made by R2? This is the written communication made by R1 saying that we don't have any objection. My lord, to this kindly I request you to see page 8, my lord. Sorry, annexure 8. Yes, annexure S. Annexure S, page 84, my lord. Annexure S, page 84. My lord, this is a written communication by R2 to R1. I'll just straight away go to Ullekha, my lord. Pradhikarada Pratyeda Krama Sankhya 5/3/2013. My lord, what I read, annexure P is dated 5/3/2013. Sarkarada Pratyeda Sankhya so-and-so reference. ಮೇಲಿನ ವಿಷಯಕ್ಕೆ this is ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಕಾನೂನು ಸೇವೆಗಳ ಪ್ರಾಧಿಕಾರದ ನಿಯಮ 1996 ಶೆಡ್ಯೂಲ್ 1 ಕ್ರಮ ಸಂಖ್ಯೆ 8 ತಕ್ಕೆ ತಿದ್ದುಪಡಿ ಮಾಡುವ ಬಗ್ಗೆ ಉಲ್ಲೇಖ ತಮ್ಮ ಪತ್ರದಲ್ಲಿ ಪ್ರಾಧಿಕಾರದ ಪ್ರಸ್ತಾವಿಸಿದ ತಿದ್ದುಪಡಿ ಸರ್ಕಾರ ಮಟ್ಟದಲ್ಲಿ ಅಭ್ಯಂತರವಿರುವುದಿಲ್ಲ ಅಂತ ತಿಳಿಸಿದ ಮೇರೆಗೆ ತಿದ್ದುಪಡಿ ಮಾಡಬೇಕಾದ ನಿಯಮದ ಬಗ್ಗೆ ಅನುಬಂಧದಲ್ಲಿ ಅಂದ್ರೆ ಅನೆಕ್ಷರ್ ತಯಾರಿಸಿ ಇದರೊಂದಿಗೆ ಲಗತ್ತಿಸಿ ಕಳಿಸಲಾಗಿದೆ. ಸೂಕ್ತ ಅಧಿಸೂಚನೆ ಕೊಡಲು ಸರ್ಕಾರವನ್ನು ಕೋರಿದೆ. ಅಂದ್ರೆ R2 annexure, sir, my lord, this is dated 26/4/2014, my lord. Subsequent to this communication, on previous day, I have submitted a memo along with a gazette of notification, my lord. Kindly see, this is dated 5/3/2016, my lord.
Now they have made an amendment.
Exactly, my lord.
Where is that?
ನಾನು ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ ಮೈ ಲಾರ್ಡ್. ನೆನ್ನೆ 11th ಗೆ ನಾನು ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀನಿ ಮೈ ಲಾರ್ಡ್. ಅದರಲ್ಲಿ ಏನ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ, ಐ ವಿಲ್ ರೀಡ್ ಇಟ್ ಮೈ ಲಾರ್ಡ್. ಸ್ಟ್ರೇಟ್ ಅವೇ ಐ ಗೋ ಟು serial number 2, my lord. Amendment of Schedule 1 in the Karnataka State Legal Service Authorities rule
24/9/24.
Sorry, my lord. This is 5/3/2016 ಗೆ.
ಅಲ್ಲ ನೀವು ಯಾವತ್ತು ಮೆಮೊ ಹಾಕಿದ್ರಿ?
11th, my lord.
11/6/25.
Yes, my lord.
Yes.
ಅದರಲ್ಲಿ third ಅದರ ಗೆಜೆಟ್ ಇದೆ my lord, ಕರ್ನಾಟಕ ರಾಜ್ಯ ಪತ್ರ ಅಂತ.
Yes.
ಅದರಲ್ಲಿ serial number 2, my lord. Amendment of Schedule 1, my lord. This is Schedule 1 ಗೆ ನಾವು amendment ಕೇಳ್ತಾ ಇದ್ದಿದ್ದು. In the Karnataka State Legal Service Authority Rule 1996, for Schedule 1 the following shall be substituted, namely Karnataka State Legal Service Authorities Rules 1996 Schedule 1. My lord, this is the one where the R2 was recommended to make certain amendments, and even on such a such date, previous date, R1 also the state government clearly mentioned.
Amendment ಆಯ್ತು ಬಿಡಿ, ಏನೀಗ?
Amendment serial number 11, my lord. Serial number page 3, serial number 11, my lord. For the post of assistant. Kindly see the for the post of assistant, my lord. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ, number of total posts, my lord. As of 5/3/2016, total there were 10 posts. Out of 10 posts, 50% from direct recruitment, 50% from the internal promotion, my lord. What are the criteria from promotion, my lord? Must have put in not a service less than 5 years of service in the cadre of junior assistant, my lord. My lord, I have completed almost 23 years of service as of 5/2/2016, because I joined in 1980 as a contract employee. My services was been regularized in 1990. 1990 ಇಂದ 2013 ತನಕ there was no promotion. In fact, I have retired with the same designation. When I retired in 31st June 2016, and my colleague first petitioner retired in 30th June 2016. But we both retired with the same designation, my lord. No promotion at all, my lord. Idu bandu, this amendment was effective 5/3/2016, my lord. On the date of this gazette, we both were first petitioner and me, we both are in service, my lord. But unfortunately, this was not executed, my lord. Now, subsequent to the, my lord, ide memo dalli, kindly see the memo given by R2, my lord, dated 27/3/25. ನಾನು ಈ ಮೆಮೋದಲ್ಲಿ ಒರಿಜಿನಲ್ ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಫ್ರಮ್ R2, my lord, ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟೀಸ್.
ಆಯ್ತು, ಈಗ ಏನ್ ಹೇಳಿ?
ಅಲ್ಲಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ, ಅವ್ರು ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂದ್ರೆ, we just sought seniority list, my lord, for the sake of promotion. ಅವರು ಕ್ಲಿಯರ್ ಕಟ್ ಆಗಿ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದ್ದಾರೆ ಇನ್ ರಿಟರ್ನ್ ಕಮ್ಯುನಿಕೇಶನ್, ಥರ್ಡ್ ಪೇರಾ, ಮೈ ಲಾರ್ಡ್. ಆದರೆ ಕಡತವನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ 1/3/2016 ಗೆ ಕ್ಲರ್ಕ್ ಕಮ್ ಟೈಪಿಸ್ಟ್ ಹುದ್ದೆಗೆ ಸಂಬಂಧಿಸಿದ ಯಾವುದೇ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಯ ಲಭ್ಯ ಅಂದ್ರೆ ಪ್ರಮೋಷನ್ ಲಿಸ್ಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಮೈ ಲಾರ್ಡ್. ಆಸ್ ಆನ್ this gazette 5/3/2016 ಗೆ we were only 3 people, my lord. First petitioner, me, and there was one more petition person in the same designation, my lord. So therefore it is very clear cut written communication happened between respondent number 2, respondent number 1, and in fact, my lord, I have given so many representations respondent number 1 seeking promotional aspects, my lord. 25 years of service, my lord, nandu 1990 in the 2016 tanka 26 service without a single promotion.
You are already retired from the service.
Yes, so therefore I am seeking only arrears as well as pension benefits.
Which law permits that? Promotion, see, you can't claim it as a matter of rights. If junior is promoted, then only will get in a right.
Correct, my lord.
You can't insist the employer to say that I have to give a promotion.
No,
it is for,
I'm
even
not
if there is a vacancy, it is for that employer to decide.
I completely agree.
Employer cannot promote that junior, then only right will be created.
Exactly correct. As per seniority list, as on,
even then, if any persons who is not promoted subsequently promoted, unless his junior is.
Subsequent promotion agide.
ಯಾರಿಗೆ ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ?
ಅಲ್ಲ third person ಗಾಗಿದೆ 2018 ಗೆ. So I am the first petitioner.
ನೀವು ಯಾವಾಗ ರಿಟೈರ್ಡ್ ಆದ್ರೆ?
ನಾನು 30th June July 21st my lord. 31st July 31st 7 2016 and
for that only you have retired, Mr.
ಅಲ್ಲ correct, but on the date of gazette I was in service.
Show me any law saying that since you have not been promoted, therefore you are entitled for all arrears. There is
ಅಲ್ಲ
no
my
such.
lord, ನಂದು
Only law is that if junior is promoted, then you are the entitled. Otherwise, it's for that employer, Mr.
No, I agree my lord. But ಇಲ್ಲಿ ನಂದು ಒಂದು
It is
request.
agreed, then it's enough.
ಅಲ್ಲ ನಂದು ರಿಕ್ವೆಸ್ಟ್ ಏನಂದ್ರೆ
ಬರಲ್ಲ ಅದನ್ನ ತೋರಿಸಿ ನನಗೆ.
ಅಲ್ಲ my lord, see on the date of this gazette I was in service. ನನಗೆ ಅವತ್ತು ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗ್ಬೇಕಿತ್ತು, ಆಗ್ಲಿಲ್ಲ my lord, unfortunate.
ಆಯ್ತು ರೀ, ಪ್ರಮೋಷನ್ ಪೋಸ್ಟ್ ಇದ್ರೂ ಕೂಡ
ಇತ್ತು ಅವಾಗ, as on that date ಇತ್ತು.
It is for the employers to grant it or not. You cannot say that I have to be given a promotion.
ಅಲ್ಲ ಅವತ್ತಿನ ದಿವಸ ಕೊಡ್ಬೇಕು. ಅದೇ ಈಗ
ನಿಮ್ ಜೂನಿಯರ್ ಗೆ ಏನಾರ ಕೊಟ್ಟಿದ್ರೆ then you can claim that rights from the date of the junior has been promoted. Yes. No, ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ promotion. Yes, yes. Yes, when do you want? Yes, we'll hear that. Yes, he wants time now. Now there is no urgency. Yes. Least this matter of 4 weeks. Let us see. Yes.
Serial number 42.
You file an objection in the meantime. Yes.
Serial number 42. Muralidhar KD.
I appear for petitioner in this case, my lord. So the morning it was, my lord, government educator directed to notice whether the amount has been paid. That 1,85,000.
Amount, what has happened? Where is your affidavit? Honorable Court had directed to release that pension benefit to the petitioner as disciplinary proceedings were concluded and so on. So I submitted that in the disciplinary proceeding penalty was imposed, withholding 1 for permanent basis. Pension basis I have shown so 8%. I submitted compliance with the directions of this court and so on. See, the copy of the order bearing is produced. Perusal. I submitted the highest respect to the order of this court. Honorable Court directed the respondent to calculate and disperse the interest on 8%. ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ರಲ್ಲ, ಏನಾಯ್ತು ಈಗ?
That order has been passed, but they have not released the amount, my lord. So far,
Yes,
amount
Mr.
has not been credited to her account. But she is a poor lady, that amount has to be credited, my lord.
Wait, huh? No, you ask that officer to be present, Mr. You ask him to present. See, even this court has directed, you have not done it. Then after this court has called upon you to file an affidavit, now this order has been passed on 20th/3/2025. Even that amount is not released. What is this, Mr.? ಎಲ್ಲಿದೆ ಕೊಡಿ, ಎಲ್ಲಿ ಆಯ್ತ್ರಿ ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದೆ, ದುಡ್ಡು ರಿಲೀಸ್ ಮಾಡಿರೋದಕ್ಕೆ ಏನಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್? ಹ್ಯಾವ್ ಯು ನಾಟ್ ಕಾಲ್ಡ್ ದಟ್ ಆಫೀಸರ್ at 2:30? Ask him to come at 4:30. Ask him to, when you are asked that, he has to verify and commit, Mr. Each time you are going and asking and coming that. Ask him to present before tomorrow. Yes, leave this matter tomorrow with that records. Yes, leave this matter tomorrow.
Serial number 46.
Who has filed that affidavit?
K. Srinivasa.
Ask him to present with all documents, Mr. Tomorrow. Yes.
Serial number 46.
My lord, I appear for the petition.
Serial number? Yes, yes.
But before commencing, my lord, I would like to pass on a memo, my lord, stating.
46. Who is your opponent?
Lord,
State.
no, my lord, the Panchayat.
You
Jilla Panchayat.
Yes.
I may be permitted to pass on the memo, my lord. Which is, my lord, regarding the appointment of the petitioner, my lord, was done in the year 2010, my lord.
Yes.
Annexure A is the proceedings, my lord, passed by the 5th respondent, by which, my lord, the petitioner was appointed as, my lord, the computer operator cum clerk.
Where is that annexure?
Annexure A, my lord. page number, my lord, 39, 40.
Yes.
Dated, my lord, 4/3/2010. Lord, the typed copy, my lord, is placed at annex, page 43.
Yes.
I may be permitted to read, my lord. The Grama Panchayatiyalli computer operator ಮತ್ತು ಕ್ಲರ್ಕ್ ಆಗಿ ಭಾಗ್ಯ ಜೆ ಓಂ ಜಯರಾಮ್ ಎಂಬುವರನ್ನು ಹಾಲಿ ಕೆಲಸ ಮಾಡಲು ನೇಮಕ ಮಾಡಿಕೊಳ್ಳುವಂತೆ ಸಭೆ ಸರ್ವಾನುಮತದಿಂದ ತೀರ್ಮಾನಿಸಲಾಯಿತು.
Yes.
Lord, this is the proceedings passed by the fifth respondent, and the petitioner was, my lord, appointed in accordance with the, my lord, the provisions made available under the Panchayat Raj Act 1993.
Yes.
Lord, the petitioner, my lord, initially appointed as clerk cum computer operator. Lord, in the year 2014, my lord, the government has issued a notification, Annexure K, my lord, page number 106. There, my lord, the government has issued a clarification stating that the panchayats are appointing the employees which are not cadred, and their designations are also not forthcoming in the page, my lord, 106, my lord, Annexure K.
Yes.
There, my lord, the government has issued certain directions to absorb the employees who have been appointed, Lord, where there was no sanction post.
Yes.
Kindly see, my lord, page number 108, my lord, of the same annexure.
Yes.
Dated 15/11/2014.
Yes.
Lord, clause number 3, my lord.
Yes.
Read it, my lord. In the right portion, my lord, that is the amended portion, my lord. The earlier existing, my lord, is left side, and the clarification.
1/1/94 ಆದೇಶದಲ್ಲಿ ಕ್ಲರ್ಕ್ ಅಟೆಂಡರ್ ಕಮ್ ಬೆರಳಚ್ಚುಗಾರರ ಹುದ್ದೆ 4/1/28 ಅಧಿಕೃತ ಜ್ಞಾಪಕ ಹುದ್ದೆ ಮಂಜೂರಾಗಿರುತ್ತೆ. ಎಂಟ್ರಿ ಹುದ್ದೆಯಿಂದ ಮರು ನಾಮಕರಣ ಮಾಡಲಾಗಿದೆ. ಈ ಹುದ್ದೆಯನ್ನು ಭವಿಷ್ಯಾನ್ವಯವಾಗಿ ಜಾರಿಗೆ ಬರುತ್ತದೆ. ಎಸ್.
ಆದಾಗ್ಯೂ ಕ್ಲರ್ಕ್ ಕಮ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಎಂದು ಗ್ರಾಮ ಪಂಚಾಯತಿಗಳು ನೇಮಕ ಮಾಡಿಕೊಂಡಿದ್ದರೆ ಕ್ಲರ್ಕ್ ಕಮ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಹುದ್ದೆಗೆ ಅನುಮೋದನೆ ನೀಡುವ ಬದಲು ಸದರಿ ಆದೇಶಗಳಲ್ಲಿ ನಿಗದಿಪಡಿಸಿರುವ ವಿದ್ಯಾರ್ಹತೆಯ ಅನುಸಾರ ಕ್ಲರ್ಕ್ ಹುದ್ದೆಗೆ ನೇಮಕ ಮಾಡಿದರೆ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಎಂಬುದನ್ನು ಹೊರತುಪಡಿಸಿ ಕ್ಲರ್ಕ್ ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳುವುದಕ್ಕೆ ಅನುಮೋದನೆ ನೀಡಬಹುದಾಗಿದೆ. Lord, initially, my lord, there was no post of computer operator. My lord. The post of clerk was available. Lord, from 2014, my lord, the government has issued this notification. In case if an employee is appointed as computer operator, their designation can be changed to clerk cum computer operator. Lord, this, my lord, is the notification, my lord, based on which, my lord, I represented to the respondents, requesting to the change the cadre as a computer operator, the clerk cum data entry operator. Lord, thereafter, my lord, while annexure Q, my lord, my services came to be absorbed, my lord, by the the second respondent, with effect from 6/6/2020, my lord.
18/6/2018.
My lord, that is, my lord, the clarification issued by the government, the second respondent, wherein, my lord, he directed for the fifth respondent, Panchayat, to once again reclassify her as the computer operator and clerk. My lord, against this, my lord, I made a representation, quite annexure R, and sought for in view of the existence of the government notification, I sought to change the cadre. There is no need of, my lord, passing any fresh resolution by the court. Lord, thereafter, annexure double came to be, my lord, issued on page 129, dated 6/6/2020, my lord. My services, my lord, came to be absorbed, my lord, by the second respondent as a clerk cum data entry operator. My lord, I am at serial number 8 in the said list, page number 130, my lord.
G. Bhagya.
Please, my lord.
Yes.
I am at serial number 8. My services came to be absorbed, my lord, as clerk cum data entry operator. My lord, above that, my lord, one Lakshmi, my lord, who is at serial number 4. She was also, my lord, clerk cum data entry operator, appointed earlier to me, my lord, in 2007.
Yes.
So accordingly, my lord, the designations, my lord, have been changed. Subsequently, my lord, I made a representation, my lord, because, my lord, the clerk cum data entry operator, my lord, there are a large number of people.
Yes.
in the district. So in case of clerks, my lord, there are less number of employees.
Yes.
I requested, as per the government order dated at the annexure K, my lord, I requested the respondent to reclassify my designation. My lord,
ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮಗೆ
my lord, I was designated.
ಕ್ಲರ್ಕ್ ಕಮ್ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಅಂತಾನೆ ಇದೆಯಲ್ಲ.
ಇದೆ, ಅದನ್ನ ಚೇಂಜ್ ಮಾಡ್ಬೇಕು ಅಂತ ನಾನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು, because as per the government notification at annexure K, I have to be reclassified as clerk cum data entry operator from 2014.
Oh, clerk cum data entry operator.
Yes.
What is the difference now?
My lord, the difference, my lord, the government.
No, you have been shown as a clerk cum data entry operator only.
Yes, my lord.
Page 130.
Page 130, my designation is shown as clerk cum data entry operator. My request, my lord, was to redesignate me as clerk, because initially, my lord, there was no post of the computer operator or data entry operator. It was introduced only for the first time since 2014 onwards. The similarly placed employees, my lord, have been reclassified as clerks, my lord. The number of posts, my lord, in the district in the cadre of clerks are less. My lord, if I am classified as clerk cum data entry operator, I will be, my lord, brought down, my lord, in the seniority.
No, see, where is that government order says that adagi clerk cum computer operator ಎಂದು ಗ್ರಾಮ ಪಂಚಾಯತ್ ನೇಮಕೊಂಡಿದ್ದರೆ ಕ್ಲರ್ಕ್ ಕಮ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಹುದ್ದೆಗೆ ಅನುಮೋದನೆ ನೀಡುವ ಬದಲು ಸದರಿ ಆದೇಶ ನಿಗದಿಪಡಿಸಿರುವ ವಿದ್ಯಾರ್ಥಿ ಸರ ಕ್ಲರ್ಕ್ ಹುದ್ದೆಗೆ ನೇಮಕಗೊಂಡಿದ್ದರೆ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಎಂಬುದಕ್ಕೆ ಹೊರತುಪಡಿಸಿ ಕ್ಲರ್ಕ್ ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳುವುದಕ್ಕೆ ಅನುಮೋದನೆ. All has to be treated as a clerk.
I have to be treated only as clerk, my lord. This request of mine, my lord, was not considered by the authorities. On the other hand, my lord, the other employee by name Lakshmi, my lord, who's, my lord, the revised order, my lord, I have passed on just now. She was, my lord, redesignated, my lord, as a clerk from the date of her entry into service.
Panchayat, same panchayat.
No, she is from different panchayat, but the second respondent is the authority, my lord, who has to redesignate it.
Ramanagara Jilla Panchayat.
Yes, my lord.
Who has to classify it? Jilla.
The second respondent, Jilla.
You are in which Jilla Panchayat?
I am in Ramanagara district, my lord.
She is also in the Ramanagara.
Yes, yes, my lord. We are both of them are in the same district.
Where is your representation?
Lord, I made series of representations, my lord. The one of which, my lord, is my lord, last representation, my lord, is made on, my lord.
ಇದೇನು ಕ್ವಾಶಿಂಗ್ ಅದು ಇದು ಎಲ್ಲ ಕೇಳಿದ್ರಲ್ಲ ಯಾಕೆ?
Lord, similarly placed employees, my lord, have been, my lord, given with the benefit of reclassification, whereas, my lord, I have not denied of the said opportunity. Hence, my lord, I have challenged this because they have been, my lord, placed above me, my lord, in the seniority list. That is the reason I have challenged the, my lord, the classification of those, the respondents number, my lord, the 5th to
ಅವ್ರ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಯಾಕೆ ಚಾಲೆಂಜ್ ಮಾಡ್ತೀರಿ? ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ನನಗೆ ಕೊಡಿ, ನಂದನ್ನ ಸೀನಿಯಾರಿಟಿನ ರೀಡೂ ಮಾಡಿ ಅಂತ ಕೇಳ್ತಾರೆ.
That's all, my lord. My
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದು ಕ್ವಾಶ್ ಮಾಡಿದ್ರೆ ನಿಮಗೂ ಕೊಡಲ್ಲ, ಅವ್ರಿಗೆ ಕೊಡಲ್ಲ ಅಂತಾರೆ ಅವ್ರು ಅಷ್ಟೇ.
My lord, stand corrected. My lord, I am not, my lord, against them.
You know, treated as in a clerk.
Yes.
Then seniority has to be redone,
my lord, and my designation has to be done. My lord, I am relying on the, my lord, the order passed by the second respondent, which I passed on now.
Yes.
Both of the petitioner and Srimati Bhagya, my lord, the Lakshmi, who is the respondent number 15 before the Honorable Court. Both of them, my lord, are in the same cadre.
Yes, Mr. Swami.
Annexure A. Her appointment is as computer operator, clerk. Ideal representation by suppressing the fact that same Gram Panchayat subsequent representation puna ಬೇರೆ ಮಾಡಿದೆ. I pass on that. This is the basis. ಇದು ನಾವು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ವಿ ಅದೊಂದಲ್ಲ, ಡೈರೆಕ್ಷನ್ ಅಲ್ಲಿ ಬೇರೆಯವ್ರು ಕೊಟ್ಟಿದ್ದು, ಅದಕ್ಕಿಂತ ಮೊದಲೇನೆ ಮಾಡಿ ಆಗಿದೆ ಇವರು. ಯಾವಾಗ ಅಂದ್ರೆ 11/2/2015 ಮಾಡಿದ್ದಾರೆ.
ಇದೇನಿದು ಅನೆಕ್ಷರ್ ಎ?
ಅನೆಕ್ಷರ್ ಎ ಅಲ್ಲಿ ಅವರ ಫಸ್ಟ್ ಇದು ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಕ್ಲರ್ಕ್, ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಇರ್ಲಿಲ್ಲ. ನಾಟ್ ಕ್ಲರ್ಕ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಅಲ್ಲ, ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಕಮ್ ಕ್ಲರ್ಕ್. ಅದು ಅವ್ರು ಹೇಳಿ ತಪ್ಪದು. ಪೇಜ್ 43 ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗ್ತದೆ.
Yes.
Computer operator come clerk, not clerk come computer operator.
ಎಲ್ಲಿದೆ ಅದು?
Page 43 ಎಲ್ಲಿದೆ?
43. Yes.
ಗ್ರಾಮ ಪಂಚಾಯತ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಮತ್ತು ಕ್ಲರ್ಕ್. ಇಸ್ ನಾಟ್ ಕ್ಲರ್ಕ್ ಕಮ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್. ಕ್ಲರ್ಕ್ ಕಮ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಇದ್ರೆ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಬಿಟ್ಬಿಡಿ ಕ್ಲರ್ಕ್ ಅಂತ ಮಾಡ್ಬೋದಿತ್ತು. ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್
ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್
ಕಮ್ ಕ್ಲರ್ಕ್ ಮತ್ತು ಕ್ಲರ್ಕ್.
ಕ್ಲರ್ಕ್
ಅದನ್ನು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಈ ರೆಸಲ್ಯೂಷನ್ ಅಲ್ಲಿ 11(2) ದಿಸ್ ಒನ್ ಹಿಯರ್ ಸಪ್ರೆಸ್ಡ್ 11(2)15ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಇದರಲ್ಲಿ ಐಟಮ್ ನಂಬರ್ 5 ಪೇಜ್ 2 ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಹುದ್ದೆಯನ್ನು ಕ್ಲರ್ಕ್ ಡಾಟ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಮರು ನೇಮಕ ಮಾಡುವ ಬಗ್ಗೆ ಸದೃ ವಿಷಯ ಸಂಬಂಧಿಸಿದಂತೆ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಆಗಿ ಇದ್ದು ಅವರು ಹೇಳ್ತಾರೆ ಕಂಪ್ಯೂಟರ್
ಆಪರೇಟರ್ ಮಾಡಿದ್ರಿ.
ಹೌದು 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 2015 ಅವರು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟರೆ ತಪ್ಪು ಅಂತ ನಾವು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟದಲ್ಲ, ಅದು ಮೊದಲೇ ಮಾಡಿ ಆಗಿದೆ ಅವರು. ಇದು ಡೇಟ್ ಯಾಕೆ ರೆಲೆವೆಂಟ್ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಅಪ್ರೂವ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ದಿಸ್ ಡೇಟ್ ಇಸ್ ಟೇಕನ್ ಆಸ್ ಕನ್ಸಿಡರೇಷನ್. ಯಾಕಂದ್ರೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಏನು ರೆಸಲ್ಯೂಷನ್ ಕಳಿಸ್ತದೆ ಅದ್ರ ಮೇಲೆ ಅಪ್ರೂವ್ ಮಾಡುವಂಥದ್ದು. ಈ ರೆಸಲ್ಯೂಷನ್ ಬಗ್ಗೆ ಕಂಪ್ಲೀಟ್ ರಿಪ್ರೆಸೆಂಟ್ ಸಪ್ರೆಸ್ ಮಾಡಿದ್ದಾರೆ, ಹೇಳೇ ಇಲ್ಲ. ವೈ ಅದು 2020ಯಲ್ಲಿ ಈ ಆರ್ಡರ್ ಕನ್ಫರ್ಮಿಂಗ್ ಹಿಮ್
ಆಯ್ತು. ಅವ್ರನ್ನ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಕಮ್ ಕ್ಲರ್ಕ್ ಅಂತ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರಿ, ಆಮೇಲೆ ಅವ್ರನ್ನ ಯಾವ ಚೇಂಜ್ ಇಟ್ಟು
ಗ್ರಾಮ ಪಂಚಾಯತ್
ಆಪರೇಟರ್ ಕ್ಲರ್ಕ್ ಫ್ರಮ್ ಡೇಟಾ ಆಪರೇಟರ್.
ಹೌದು ಹೌದು, ಯಾರು ಗ್ರಾಮ ಪಂಚಾಯತಿ ಚೇಂಜ್ ಮಾಡಿದ್ದು, ನಾವಲ್ಲ. ಗ್ರಾಮ ಪಂಚಾಯತ್ ಇದು ಗ್ರಾಮ ಪಂಚಾಯತ್ ರೆಸಲ್ಯೂಷನ್ ಅವರೇ ಚೇಂಜ್ ಮಾಡಿದ್ದು. ಆನ್ ದಿಸ್ ಬೇಸಿಸ್ ಇದು ಮಾಡಿದ ಬೇಸಿಸ್ ಅಲ್ಲಿ ನಾವು ಅಪ್ರೂವಲ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಈ ಡೇಟ್ ಇಂದ.
ಈ ಡೇಟ್ ಇಂದ ಕೊಟ್ಟಿದ್ರಿ. ವಾಟ್ ಇಸ್ ದಿಸ್ ಪೇಜ್ 108? 108 ಅಲ್ಲಿ ಕ್ಲರ್ಕ್ ಕಮ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಎಂದು ಗ್ರಾಮ ಪಂಚಾಯತ್ ನೇಮಕಗೊಂಡಿರೋರ್ನ ಕ್ಲರ್ಕ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದಾರಲ್ಲ, ಇದ್ಯಾರ್ದು ರೆಸಲ್ಯೂಷನ್ ಇದು?
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಗವರ್ಮೆಂಟ್ ಮಾಡಿರೋದು.
ಗವರ್ಮೆಂಟ್ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದೆಯಲ್ಲ ಎಲ್ಲರೂ
ಕ್ಲರ್ಕ್ ಕಮ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಬಿಟ್ಬಿಡಿ. ಇದು ಹಾಗಲ್ಲ, ಇದು ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಕ್ಲರ್ಕ್ ಅದೇ ಎಲ್ಲ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇರುವುದು ಹಾಗೇನೆ. ಫಸ್ಟ್ ಪೋರ್ಷನ್ ಇಂದ ತಗೊಳ್ಳಿ, ಇನ್ನೊಂದು ಬಿಟ್ಬಿಡಿ ಅಂತ ಹೇಳಿ. ಇಲ್ಲಿ ಕ್ಲರ್ಕ್ ಕಮ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಅಲ್ಲ ಇವರು ಆಗಿದ್ದು, ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಮತ್ತು ಕ್ಲರ್ಕ್ ಹಾಗೆ.
ಫಸ್ಟ್ ಇಸ್ ದ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್.
ಹೌದು ಹೌದು, ಆದ ಕಾರಣ ಸೆಕೆಂಡ್ ಪೋರ್ಷನ್ ತಗೊಳ್ಳಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಅದನ್ನು ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಹೇಳಿದ್ದು ಹಾಗೆ.
ಫಸ್ಟ್ ಪೋರ್ಷನ್ ಯಾವ್ದಿದೆ ಅದನ್ನ ಮಾತ್ರ
ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿ ಅದು ಹೇಳಿದ್ದು. ಇದು ಇಂಥದ್ದು ಸುಮಾರು ಕೇಸ್, ಒಂದು ಕೇಸ್ ಇಲ್ಲ
ಆ ತರ ಏನಿಲ್ಲ.
now he has been made as a clerk come data operator.
ಹೌದು, ರೆಸಲ್ಯೂಷನ್ ಮಾಡಿದ್ರು ಅವರು.
ಮಾಡಿ
ಅದರ ಪ್ರಕಾರ ಮಾಡಿದ್ವಿ ನಾವು.
ಅಲ್ಲ, now he is become a first portion is clerk.
ಹೌದು, ಈ ಕ್ಲರ್ಕ್ ಕಮ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್. ಕ್ಲರ್ಕ್ ಕಮ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಯಾವಾಗ ರೆಸಲ್ಯೂಷನ್ ಮಾಡಿದ್ವಿ ಆ ಡೇಟ್ ಇಂದ ಮಾಡಿದ್ವಿ.
Now he has been now he is a clerk come
data operator.
Data operator.
ಡೇಟ್ ಯಾವ್ದಂದ್ರೆ ಇವ್ರು ರೆಸಲ್ಯೂಷನ್ ಮಾಡಿದ್ರಲ್ಲ
2015 ಆಯ್ತು. Now he is saying that I can be do it only a clerk, not that data operator. That is what is requested. ಈಗ ಗವರ್ಮೆಂಟ್ ನವರು ಫಸ್ಟ್ ಪೋರ್ಷನ್ ಯಾವ್ದಿದೆ ಕ್ಲರ್ಕ್, ಅದನ್ನ ಇಟ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. ನನಗೆ ಈಗ ಬರೀ ಕ್ಲರ್ಕ್ ಮಾಡಿ ಕ್ಲರ್ಕ್ ಕಮ್ ಡೇಟಾ ಆಪರೇಟರ್
ಅದು ಹೇಳೋದಲ್ಲ ಅವರು. ಅವ್ರು ಹೇಳೋದು ಈ 2010 ರೆಸಲ್ಯೂಷನ್ ಇದೆಯಲ್ಲ ಅದ್ರ ಪ್ರಕಾರ ಮಾಡಿ ಅಂತೇಳಿ. ಹೌದು, ಆ ಡೇಟ್ ತಗೊಳ್ಳಿ. ಅವ್ರ ಏನ್ ಸಬ್ಸ್ಟೆನ್ಸ್ ಅಂದ್ರೆ 2015 ಕೊಟ್ಟಿದ್ವಿ, ಏನ್ ತಾಪತ್ರ ಇಲ್ಲ.
2015 ಅಲ್ಲಿ ನೀವು ಕ್ಲರ್ಕ್ ಕಮ್ ಡೇಟಾ ಆಪರೇಟರ್ ಕೊಟ್ಟಿದ್ದೀರಾ. ಈ ಸೇಯಿಂಗ್ ದಟ್ ಐ ಮೇ ಬಿ ಟ್ರೀಟೆಡ್ ಆಸ್ ಓನ್ಲಿ ಎ ಕ್ಲರ್ಕ್.
ಇಲ್ಲ ಅದಲ್ಲ.
ಹೌದೌದು, ಅಷ್ಟೇ.
ದಟ್ ಇಸ್ ಮೈ ಕೇಸ್ ಲಾರ್ಡ್, ಬಿಕಾಸ್ ದಿ ಅದರ್
ಇವರು
ಕ್ಲರ್ಕ್ ಕಮ್ ಡಾಟ್
ಆಪರೇಟರ್ ಕನಕಪುರ ತಾಲೂಕಿನ ಪಂಚಾಯತಿ ನೇಮಕಗೊಂಡಿರುವ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ನೇಮಕಾತಿ ಕಚೇರಿ ಸಮಸಂಖ್ಯೆ ಅನುಮೋದನೆ ನೀಡಿದ್ದು ಕ್ಲರ್ಕ್ ಕಮ್ ಡೇಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಒಳ್ಳೆಗಾಲದ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅನುಮೋದಿಸಿರೋದನ್ನು ಕ್ಲರ್ಕ್ ಕಮ್ ಬೆರಳಚ್ಚುಗಾರರು ಎಂದು ಓದಿಕೊಳ್ಳತಕ್ಕದ್ದು.
ಹೌದು,
ಅವ್ರು ನೋಡಿ ಇದು ಈಗೊಂದು ಮೆಮೊ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ, ಸೇಮ್ ಅವ್ರದ್ದು ಕೂಡ ಕ್ಲರ್ಕ್ ಕಮ್ ಡೇಟಾ ಆಪರೇಟರ್ ಆಗಿ ಮಾಡಿದ್ದೀರಾ.
ಹೌದು, ಕರೆಕ್ಟ್. ಆದ್ರೆ ಇವ್ರದ್ದು ಹಾಗಲ್ಲ, ಇವ್ರದ್ದು ಕಂಪ್ಯೂಟರ್ ಕಮ್ ಇದು
ಅಲ್ಲ, ಕ್ಲರ್ಕ್ ಕಮ್ ಡೇಟಾ ಆಪರೇಟರ್ ಇವ್ರದ್ದು.
ನಿಮ್ದು ಆಗ್ರಿಮೆನ್ಸ್ ಅಲ್ಲ ಅವ್ರದ್ದು. ಅವ್ರು ಏನ್ ಹೇಳು ಅಂದ್ರೆ ನಮ್ಗೆ 2015 ಅಲ್ಲ 2010 ಕೊಡ್ಬೇಕು ಸೀನಿಯಾರಿಟಿ ಅಂತ ಹೇಳುವಂಥದ್ದು.
ಇಲ್ಲ ಇಲ್ಲ, ಅವ್ರ
I am only regarding my designation, my lord, not from
ಅವರು. ಯಾಕೆ ಅಂದ್ರೆ ಕ್ಲರ್ಕ್ ಡೆಸಿಗ್ನೇಷನ್ ಕೊಟ್ರೆ ಪ್ರಮೋಷನ್ ಅವೆನ್ಯೂ ಜಾಸ್ತಿ ಇದೆ. ನನ್ನನ್ನು ಬರೀ ಕ್ಲರ್ಕ್ ಅಂತ ಕರೀರಿ, ಡೋಂಟ್ ಕಾಲ್ ಹಿಮ್ ಆಸ್ ಎನ್ ಕ್ಲರ್ಕ್ ಕಮ್ ಡೇಟಾ ಆಪರೇಟರ್. as like you see that
ಇಲ್ಲ ಅವ್ರು ಮೊದಲಿಂದ ಕೂಡ ಕೊಟ್ಟದ್ದು ರೆಪ್ಯುಟೇಷನ್ ಸಪ್ರೆಸಿಂಗ್ ದಿಸ್ ಹಾಕಿ ಇದ್ರ ಪ್ರಕಾರ
ರೆಪ್ರೆಸೆಂಟೇಷನ್
ಮೊದಲಿಂದ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೂಡ
ಎಲ್ಲಿ ತೋರಿಸಿ. ಅವರು ಅದು ಅಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ, ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಾ. ಎಸ್, ಯು ವಿಲ್ ಸಿ ದಟ್ ವಾಟ್ ಇಸ್ ದ ರೆಪ್ರೆಸೆಂಟೇಷನ್.
Which
is that representation?
Lord, my last representation, Lord, is Page number 154, my lord. 153. It was submitted on, my lord, the 16th May 2022.
Page 153.
153.
ಏನಂತ ಕೇಳಿದ್ದೀರಾ?
Lord, ರಾಮನಗರ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಪ್ರಕಟಿಸಿರುವ ರಾಮನಗರ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಗ್ರಾಮ ಪಂಚಾಯತಿಗಳ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿರುವ ಗುಮಾಸ್ತ, ಬೆರಳಿಕೆಗಾರ, ಅಕೌಂಟೆಂಟ್, ಗುಮಾಸ್ತ ಕಮ್ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ವೃಂದದ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಯಲ್ಲಿ ರಮ್ಯಾ ಕೆ.ಎಸ್. ಹೆಸರು ಪ್ರಕಟಿಸುವ ಬಗ್ಗೆ ಆಕ್ಷೇಪಣೆ ಮತ್ತು ಸದರಿಯವರ ಕ್ಲರ್ಕ್ ಹುದ್ದೆಯನ್ನು ತಿದ್ದಿಕೊಂಡು ಅನುಮೋದನೆ ಪಡೆದಿರುವ ಬಗ್ಗೆ ಪ್ರಕರಣವಿದ್ದು, ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ ಸೋನ್ಸೋರಲ್ಲಿ ರಮ್ಯಾ ಪ್ರತಿವಾದಿಯಾಗಿದ್ದು, ರಮ್ಯಾರವರ ನೇಮಕಾತಿಯನ್ನು ಉಚ್ಚ ನ್ಯಾಯಾಲಯ
ಏನಂತ ಕೇಳಿದ್ರೆ ಕೆ ರಮ್ಯಾ ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರತಿವಾದಿಯಾಗಿ ಸದರಿಯವರು ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ನೀಡುವ ಅನುಮೋದನೆಗೆ ಪ್ರಕಾರ ನಿಯಮಾನುಸಾರ ಮರುನಾಮಕರಣ ಮಾಡುವುದು ಅವಶ್ಯಕತೆ ಆಗಿದೆ. ಅಲ್ಲದೆ ಸದರಿ ವಿಷಯವನ್ನು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಅರ್ಜಿ ಸದರಿ ವಿಷಯ ನ್ಯಾಯಾಲಯದ ತೀರ್ಮಾನಕ್ಕೆ ಒಳಪಟ್ಟಿದ್ದು, ಜ್ಯೇಷ್ಠ ಪಟ್ಟಿಯ ಮುಂದಿನ ನೇಮಕಾತಿ ಮಾಡಿದ್ದು 13ನೇ ಪ್ರತಿವಾದಿ ರಮ್ಯಾ ಕೆ.ಎಸ್. ಅನುಕೂಲವಾಗಲಿದೆ ಮತ್ತು ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಅನುಕೂಲವಾಗುತ್ತದೆ. ಸೂಕ್ತ ಪ್ರಕರಣ
ನನಗೇನು ಅರ್ಥ ಆಗಲಿಲ್ಲ.
ಅದೇ ಯಾವುದೇ ಹಿಂಬರ ನೀಡುವುದಿಲ್ಲ, ಸಂವಿಧಾನ ನಾಮಕರಣ ಆದೇಶ ಪಾಲನೆ. ಆದ್ರಿಂದ ಭಾರತ ಸಂವಿಧಾನ ಅನುಚ್ಛೇದ 14-15ರಲ್ಲಿ ಮೂಲಭೂತ ಹಕ್ಕಿಲ್ಲ. ಆದ್ರಿಂದ ಪ್ರಕಾರ ಸಮಾನತೆ ಮತ್ತು ಸಾಮಾಜಿಕ ನ್ಯಾಯದಡಿ ರಮ್ಯಾ ಕೆ ಕ್ಲರ್ಕ್ ಹುದ್ದೆಗೆ ನೀಡುವ ಅನುಮೋದನೆಯನ್ನು ಅನುಸಾರ ನನಗೂ ಸಹ ಕ್ಲರ್ಕ್ ಹುದ್ದೆಗೆ ತಿದ್ದುಪಡಿ ಆದೇಶ ನೀಡಬೇಕಾಗಿ ಇಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ನೋಡಿ. ಪೇಜ್ 1.
ಈಗ ಅವ್ರು ಅಲ್ಟಿಮೇಟ್ ಏನಂದ್ರೆ, ನಂದು 2015 ತಗೊಳ್ಬೇಡಿ, 2010 ತಗೊಳ್ಳಿ, ಆಗ ನಾನು ಮೇಲೆ ಹೋಗ್ತೀನಿ ಅಂತೇಳಿ. ದಟ್ ಇಸ್ ಅಲ್ಟಿಮೇಟ್. ಅವ್ರು ಬೇಕಾದ್ರೆ ಎಲ್ಲ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಬೇಕಾದ್ರೆ ತೋರಿಸ್ತೀನಿ ನಾನು. ಇದೆಲ್ಲ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ. ಅವ್ರ ಉದ್ದೇಶನೇ ಅದು. ಯಾಕಂದ್ರೆ ನಾನು ಈಗ ಕೆಳಗಿದ್ದೀನಿ, ನೀವು ಅದನ್ನ 2010 ತಗೊಂಡ್ರೆ ನಾನು ಮೇಲೆ ಹೋಗ್ತೀನಿ.
ಅವ್ರು ಹೇಳೋದು ಏನ್ ಗೊತ್ತಾ, ಇವರು ಇಲ್ಲಿ ಯಾರು ಇದಾರಲ್ಲ,
ಲಕ್ಷ್ಮಿ, my lord, who is at serial number 15?
ಯಾರದ ಹೆಸರು?
ಲಕ್ಷ್ಮಿ, ಶ್ರೀಮತಿ ಲಕ್ಷ್ಮಿ, who is the respondent number 15?
On 11/9/2020 ತಿದ್ದುಪಡಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಅದು ಕೊಡ್ರಿ ಅವ್ರಿಗೆ ಕಾಪಿ. ಇನ್ನೊಂದು ಕೊಡಿ, ಅವ್ರು ಹುಡುಕ್ತಾ ಇದಾರೆ, ಕೊಡಿ ಅದು. ಓದಿ ಅದು ತಿದ್ದುಪಡಿ. ಅದೇ ತರ ನನಗೂ ಒಂದು ತಿದ್ದುಪಡಿ ಕೊಡಿ ಅಂತ. She is also placed in the same place.
My prayer.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಅಲ್ಲಲ್ಲ, ಡಾಟಾ ಇದು ಕ್ಲರ್ಕಮ್ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್, ಕ್ಲರ್ಕಮ್ ಬೆರಳಚ್ಚುಗಾರ ಅವ್ರು ಇವ್ರು ಮಾಡ್ಬೇಕಲ್ವಾ? ಯಾರು? ಗ್ರಾಮ ಪಂಚಾಯತ್ ಮಾಡ್ಬೇಕಲ್ವಾ? ಗ್ರಾಮ ಪಂಚಾಯತ್ ಏನ್ ರೆಸಲ್ಯೂಷನ್ ಮಾಡ್ತೀವೋ ನಾವು ಅಪ್ರೂವ್ ಮಾಡ್ತೀವಿ.
ನೋ, ಈ ಗವರ್ಮೆಂಟ್ ಸರ್ಕ್ಯುಲರ್ ನೋಡಿ, ಚೇಂಜ್ ಆಫ್ ಇದಕ್ಕೆ ಪೋಸ್ಟ್ಗೆ ನೀವು ರೆಸಲ್ಯೂಷನ್ ಮಾಡೋದ್ ಬೇಡ, ಹಂಗೆ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಅದು 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 ಬೇರೆ.
ಕ್ಲರ್ಕ್ ಕಮ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಎಂದು ಗ್ರಾಮ ಪಂಚಾಯತಿ ನೇಮಕಗೊಂಡಿದ್ದಾರೆ. ಕ್ಲರ್ಕ್ ಕಮ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಹುದ್ದೆಗೆ ಅನುಮೋದನೆ ನೀಡುವ ಬದಲು ಸದರಿ ಆದೇಶದಲ್ಲಿ ನಿಗದಿಪಡಿಸಿರುವ ವಿದ್ಯಾರ್ಥಿ ಅನುಸಾರ ಕ್ಲರ್ಕ್ ಹುದ್ದೆಗೆ
ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಬಿಟ್ಬಿಟ್ಟು ಕ್ಲರ್ಕ್ ಮಾಡಿ ಅಂತೇಳಿ. ನಾವು ರೆಸಲ್ಯೂಷನ್ ಏನ್ ಮಾಡಿರ್ತೀವಿ, ಈಗ ರೆಸಲ್ಯೂಷನ್ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅದ್ರ ಪ್ರಕಾರ ಅಪ್ರೂವಲ್ ಕೊಟ್ಟಿದೀವಿ. ಈಗ ರೆಸಲ್ಯೂಷನ್ ಬೇರೆ ಚೇಂಜ್ ಮಾಡಿದ್ರೆ ನಾವು ಮಾಡಬಹುದು.
ಕ್ಲರ್ಕ್ ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳುವುದಕ್ಕೆ ಅನುಮೋದನೆ ನೀಡಬಹುದಾಗಿರುತ್ತದೆ. ಗ್ರಾಮ ಪಂಚಾಯತಿ
ಈಗ ಅವ್ರು ಏನ್ ಹೇಳಿದ್ರೆ 2010ರಲ್ಲಿ ರೆಸಲ್ಯೂಷನ್ ಇದೆಯಲ್ಲ, ಅದ್ರ ಪ್ರಕಾರ ನಮ್ಗೆ ಕ್ಲರ್ಕ್ ಅಂತ ಮಾಡಿ ಅಂತ ಹೇಳಿ.
ಮಿಸ್ಟರ್ ಶ್ರೀನಿವಾಸ್, ಐ ಥಿಂಕ್ ಇನ್ ಕೇಸ್ ಆಫ್ ದಿಸ್ ಲಕ್ಷ್ಮಿ, ಪಂಚಾಯತ್ ಹ್ಯಾಸ್ ಸೆಂಡ್ ಎನ್ ರೆಸಲ್ಯೂಷನ್. ಇನ್ ವ್ಯೂ ಆಫ್ ದಟ್ ಶಿ ಹ್ಯಾಸ್ ಟು ಬಿ ಕನ್ಸಿಡರ್. ಅಲ್ಲಿ ಯಾಕೆಂದ್ರೆ reference ಏನು ಹಾಕಿಲ್ಲ. You verify.
There is no reference, my lord, in that
case. Yes. Whether panchayat has sent in a resolution
or the Jilla Panchayat itself has done it. I will verify.
Adon kelkoba,
please.
Yes. Yes. When do you want?
Monday or Tuesday?
Tuesday, badappa. Thursday ಹಾಕಿ ಸ್ವಾಮಿ.
Yes, next Thursday. You verify and get the records of her. Please. How it has been done.
Please.
If it is done through that panchayat, then you have to ask for a panchayat to send in a resolution.
Yes. I will ask. Yes.
First.
Serial number 51.
See, when we ask that, get any instruction regarding whether paid it or not. When he come to your office, he has to bring it. If he is not bring, you will say, I will bring next week. That is not the way they have to be answered, mister. You ask him to get it right now. It is not that the taluk office, it is in High Court. Let him bring that. Just to produce that amount has been released, he is saying that I will bring it next week. Yes. Yes, ask him to bring all this.
Serial number 51.
Lordship,
Appearing for the petitioner in this case, covered matter, Your Lordships.
Yes, what is this
Covered by
covered?
the decision of this honorable court.
Hmm.
On the day before yesterday, state government they said
Who
that
has
they will
taken the
seek
time? It is not covered.
Yes.
What is that case, Mr.?
Your Lordship may kindly see Annexure A, page number 30 of the petition, Your Lordships.
Yes.
The draft rules which are being challenged here, Your Lordship. The rule 3 at page number 32. Absorption of certain employees of Mysore Acetate and Chemical Limited in urban local bodies. The relevant portion is at page 33, Your Lordships, clause 4. Rule 3, clause 4.
Yes.
The absorption shall be effective from the date of person concerned reports to duty consequential to the appointment order.
Yes.
The same draft rules were challenged in the earlier writ petitions, Your Lordship, that I have submitted through the memo. Your Lordship has it. Not, I have an extra copy. Sorry. Your Lordship may kindly come to page number 6 of the memo.
What is that? It is challenged here.
Same thing, Your Lordship, the same draft rules. That is rule 3, Your Lordship. Shri Raghavendra G. Gayatri, the learned counsel for petitioners. Para 2, Your Lordship.
3 of class 3, subclass 2, 4, insofar as granting a benefit of absorption from the date of issuance of the notification. Yes.
Yeah, the order is at page number 11, Your Lordships.
Yes.
The petition is allowed declaring that the petitioner's absorption must be from the date they were sent on deputation to concerned local bodies, and that they must be admitted to all consequential benefits, financial benefits effective from such date, but the interest payable at 6% per annum shall only be from the date of notification of rules of 2020. The same order I am seeking in the present writ petition.
They are also seeking same prior
Since
covered by
more than 5 hearings, it is being adjourned continuously.
Now that the petitioner has been retired from service on 36/2024 on attaining the age of superannuation, only thing that so far as relating to the pensionary benefit.
See here, absorption must be from the date of they went on deputation, calculate madi or pensionary benefit.
Now that she has retired from the service.
See, in terms of that, I will dispose of retirement benefit. If they have given a representation, you have to consider.
That may be noted.
For the government.
Rural ಏನು ಹೇಳಿದ್ದಾರೆ ಅಂತಂದ್ರೆ from the date of their notification ಅಂತ ಹೇಳಿದ್ದಾರೆ. That they have challenged. This court said petition is allowed declare that petitioner absorption must be from the date they were went on deputation to the concerned local body.
Yes, sir.
ಯಾವತ್ತು deputation ಗೆ ಹೋದ್ರು
He was transferred to the present town municipality Bannur on 15/6/2012.
Reported to the duty to the consequential to that appointment order.
2001, Your Lordships. She was transferred to T. Narsipura on in the year 2001. That the statement of objection itself suffices, Your Lordships.
2001. What is
Please,
this rule
10,
says?
10/2001.
Absorption shall be effected from the date of the person concerned, reported to the duty.
Please.
Same date only.
2001, Your Lordship.
And then why that rule is challenged?
Your Lordship.
What is wrong in that rule?
Since local bodies, Your Lordship, I may be permitted to correct myself, Your Lordship. 1993, the concerned local body, she joined at in the year 1993.
Joined when you have sent in a deputation. What is your case, Mr.?
Your Lordship, the petitioner was working in Mysore Acetate.
TMC T. Narsipura, my lord. TMC T. Narsipura is dated 10/10/2001.
Published in the 60. After incurring loss in the said company was left to virtual so on. So the company sent 8 members to the Hassan Town Municipal Corporation on deputation. The service. Yes, when you have come to that Hassan Town Municipal Corporation.
2001, Your Lordship.
From that day.
T. Narsipura.
From that day it is entitled. That's
Please.
what. Earlier they are working in that ಯಾವುದೋ ಒಂದು chemical companies they are working. They have been deputed to that municipal corporation, but absorption has been done it later. Therefore, this court said from the date of deputation they have to be entitled. That's all, same thing, yes.
Your Lordship, as
Alternate counsel.
pertaining to superannuation, Your Lordship may kindly come to page number 20 of my memo. Page number 21, Your Lordship. In one of the matters, it is also been observed that in the instant case, it is seen that some of the petitioners have also attained the age of superannuation. Your Lordship, age has been. Your Lordship, the memo, Your Lordship. Yes.
Judgment.
Yes. Page number?
I may be permitted to read from page number 20. Your Lordship.
Page number?
20, para 8.
I will say that in terms of that we will dispose of.
Please, Your Lordship.
Para?
Your Lordship may kindly dispose of in that terms, Your Lordship.
No, in which is that main matter?
Main matter is the first citation, Your Lordship, page number 2. It starts from page number 2.
Yes, in terms of that, it covers everything.
Yes, Your Lordship.
Learned counsel for the petitioner submits that. The above writ petition is covered by decision of this court in WP number 10575 of 2023, disposed of on 18th July 2024. The above, in view of the above, the writ petition is disposed of in terms of that order passed by this court in WP 10575 of 2023, disposed of on 18th July 2024. Yes.
The Lordship, time period may kindly.
Otherline time period ಕೊಟ್ಟಿದ್ದಾರಾ?
Yes, ಕೊಟ್ಟಿದ್ದಾರೆ.
Same in terms of ಅಂತ ಅಂದ್ರೆ ಆಯ್ತಾ?
Please.
Yes. Other matters will take it next week.
60 minutes.
Much okay.
60.
Madam.
60 minutes.
Madam.
60.
Yep, tomorrow.
Yeah, no, what is this matter?
Writ of mandamus matters.
For what?
Madam.
Promotional review, annexure G, HJ has to be considered.
Who has to be considered?
Respond number 1 and 2. has to be.
Serial number 60.
The petitioner appointed as a
At the request of the learned counsel for the petitioner, released this matter on 18/6. What is this, Mr. Government Advocate?
annexure J, my lords. Annexure J is the representation, my
Directed the
lords.
respondent to consider that representation. Huh?
Compassionate appointment was done, my lords. Annexure A, all the documents are computed. And in view of the fact that similarly situated annexure K, my lords, will not kindly look at.
ಆಯ್ತ್ರಿ ಅವ್ರ representation
Adi,
ಏನ್ರಿ?
representation is to be considered. sir.
ಅಲ್ಲ ಏನಕ್ಕೆ representation?
Annexure K, your lordship kindly look, annexure J, my lords. Second PU ಮಾಡಿದ್ವಿ ಅಂತ. ಅಲ್ಲ, even otherwise, even other my present.
ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ
I am sorry.
representation ಏನಕ್ಕೆ ಫಸ್ಟ್ ಹೇಳ್ರಿ, ಆಮೇಲೆ ನಾನು ಹೇಳ್ತೀನಿ ಏನಂತ ಹೇಳ್ಬಿಟ್ಟು.
SDA promotions.
SDA promotion ಕೊಡ್ಬೇಕು ಅಂತ. That she is eligible.
Yes.
She is appointed to which post? She or he?
She.
She has been appointed to which post, Mr.
Water supply ಇದು ಅಂತ ಮಾಡಿದ್ದಾರೆ sir.
SDA
That was
appoint
not
ಮಾಡಿದ್ರಾ?
even
Now she wants to seek a promotion for what?
promotion of
SDA.
SDA.
SDA promotion ಗೆ seniority list ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ? What is that criteria for? What is the qualification?
ಅಲ್ಲ sir, SLC is the qualification, my lords. ಇಲ್ಲ SS. ಅಲ್ಲ
It's no first. What is that qualification which is required?
SSLC, my lords.
ಆಯ್ತ್ರಿ, ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರೆ ಸುಮ್ನೆ.
ಆಯ್ತು. ಅಲ್ಲ, I have produced documents also.
Second PUC. Second PUC ಅಂತಿದ್ಯಾ? Then you have not qualified to.
ಇಲ್ಲ, annexure K, your lordship kindly look at, my lords.
ಆಯ್ತು, ಬರ್ತೀನಿ. ಇದೇನಿದು annexure ಅಂತ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಡೋದಲ್ವಾ ಒಂದು ನಿಮ್ಮ representation ಗೆ ಕೊಟ್ರೆ ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿದಾಗ then we decide.
ಅಲ್ಲ ಅಲ್ಲ.
You consider and reject it, yes.
I request my lord to look at annexure K. my lord.
ಆಯ್ತು, ನೀವು will
ಅಲ್ಲ ಅಲ್ಲ.
directly consider your
In similarly situated case, SSLC, a person who has completed SSLC has been given SDA. my lord, sir.
Counsel, if they are rejected, then come before this court. Why are you now? Yes.
Annexure J may be considered
Yes, it
in
is
time
petition.
bound.
Petitioner has sought following relief. The case of the petitioner that petitioner father was working as what, mister?
Working as a bill collector.
Was working as a bill collector in where?
During the course of appointment,
ಯಾವ ಎಲ್ರಿ ಯಾರು ಎಲ್ಲಿ ಮಾಡ್ತಿದ್ರು?
annexure.
ನಿಮ್ ಕೇಸ್ ಇನ್ ದಿ ಫ್ಯಾಕ್ಟ್ಸ್ ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲಪ್ಪ 4 ಗಂಟೆಗೆ ಬಂದ್ಬಿಟ್ಟು ಡಿಸ್ಪೋಸ್ ಅಂತ.
ಇಲ್ಲ ಇಲ್ಲ ಇದು.
Yes. He was working as a bill collector in where, mister?
ಎಲ್ಲ ಪೌರ ಕಾರ್ಮಿಕ ಸ್ವಾಮಿ.
ಮತ್ ಬಿಲ್ ಕಲೆಕ್ಟರ್ ಅಂತೀರಾ?
ಪೌರ ಕಾರ್ಮಿಕ. He was working as a
ಪೌರ
ಪೌರ ಕಾರ್ಮಿಕ.
ಪೌರ ಕಾರ್ಮಿಕ and third respondent municipality.
ಹೌದು third respondent.
While he was in service.
15/3/2014 he died.
2014. On the basis of the request of the petitioner, he has been appointed on compassionate ground as a bill collector.
ಹೌದು.
Bill collector.
ಅಲ್ಲ ಅಲ್ಲ, ವಾಟರ್ ಸಪ್ಲೈ ಇದು ಅಂತ ಮಾಡಿದ್ದಾರೆ ಸರ್. annexure G minutes ಆದೇಶ
ಏನಂತಿದೆ?
ವಾಟರ್ ಸಪ್ಲೈ ಅಸಿಸ್ಟೆಂಟ್ ಅಂತ
He
ಮಾಡಿದ್ದಾರೆ.
has been appointed as an
ವಾಟರ್ ಸಪ್ಲೈ ಅಸಿಸ್ಟೆಂಟ್, ನೀರು ಸರಬರಾಜು ಸಹಾಯಕ ಡಿ ವೃಂದ.
assistant water supplier.
ಹೌದು.
Yes, assistant water supplier.
The next annexure is that annexure H, equivalent qualification,
So,
second year PU.
petitioner assistant as per annexure G. The grievance of the petitioner that even though petitioner is qualified to be promoted as a STA, his case has not been considered.
As per annexure H.
Therefore, he has given a representation with annexure G dated 13/8/20.
Annexure J, my lords.
J, yes.
11/8.
Annexure J to whom?
Annexure J to you, respond number 1 and 2.
Given to respondent number 1
and 2.
1 and 2. Since no action has been taken, hence petitioner before this court. Alternate government advocate appearing for the state has contended that if this court grants some reasonable time, the representation annexure J will be considered in accordance with law. In view of the above, without expressing any opinion on the merit of the case, who has to consider, mister?
Respondent 1 and 2, my lords.
Respondent number 1 and 2 is directed to consider
Implementing authority, yes, ma'am.
representation submitted by the petitioner annexure J dated 13/8/2024 in accordance with law, not later than 3 months from date of receipt of copy of this. Yes.
Much.
Lord, 61 serial number.
56 ballots.
56.
May be had on Monday ballots.
56. Yes. Leave this matter on Monday.
61 as well, my lord.
Every hearing date, they are taking the date.
Let us see on Monday. Yes.
Monday.
61, my lord. The coordinate bench is granted interim order of stay of conviction. Matter can be disposed of on that, my lord.
Serial number?
61.
What is that 61?
The petitioner got a position on rank 2.
See, what is that other matters? What is this?
Lord, serial number 59, my lord.
59.
59, my lord.
When do
Will
you
be
want?
taken up on Monday, my lord.
For
Senior
R2 and
counsel,
R3 in this case, my lord.
senior counsel has addressed the arguments on like 2 hearing dates before. Only.
What is that issues?
My lord, this is almost the 5th round of litigation before this honorable court, wherein the petitioner has sought for appointment under the for the post of associate professor, my lord, wherein his eligibility was not considered in the initial round. Thereafter, 2 contempt petitions were filed, and in the last
confused it.
My lord, they have not been served copy on it, my lordship.
My lord,
No copy has been served.
my lord, copy notice was issued almost 1 year back, my lord, and 1 year back only I had issued given process. However, I'll serve an extra copy also even now.
Yes, you better you serve
I'll do.
because
I'll serve an extra
vakalat is not filed. Yes.
A week on 2 weeks.
First copy iskali amel noda.
Please convince for me.
Tuesday. Yes.
Tuesday.
Wednesday. Yes.
My lord, serial number 55. But the short question is, my lord, single post cannot be reserved. Mangalwarna, Budhwarna hakondre. Single post, isolated post.
Yes. Leave this matter on 24th.
57, my lord.
Lord, seal number 62, my lord.
14% my lord, 57 my lord.
57.
12 years ಆಯ್ತು my lord, ಎಲ್ಲ ಆಗಿದೆ my lord. E80 ಆರ್ಡರ್ ನನ್ನಂಗ ಆಗಿದೆ, PU ಬೋರ್ಡ್ ಆರ್ಡರ್ ಎಲ್ಲ ನನ್ನಂಗ ಆಗಿದೆ my lord. ನೀವು ನೋಡಿ ಸಾಕು my lord, ಎಲ್ಲ ಆಗಿದೆ my lord. 12 years ಇದ್ರಿ my lord.
We'll have it on 30th.
ರೀಚ್ ಆಗಿ ಮಾಡಿ ಟೈಮ್ ಟೈಮರ್ ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಡಿ my lord.
Yes, interim order granted early. Yes, we'll consider.
ಟೈಮರ್ ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಡಿ my lord. 12 ವರ್ಷ ಆಯ್ತು ಟೈಮರ್ ಫಿಕ್ಸ್ ಮಾಡಿ.
Yes, on 30th we'll see.
ಅಲ್ಲ ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡಿ my lord. ಈಗ 12 ವರ್ಷ ಆಯ್ತು my lord, ಏನಿಲ್ಲ my lord ನಾನು.
ಟೈಮ್ ಅವತ್ತೆ 30ನೇ ತಾರೀಕು.
ಅಲ್ಲ ಟೈಮ್ ಒಂದು 4:30
ಫುಲ್ ಡೇ 10:30 ಇಂದ 5:30 ತನಕ ಇರ್ತೀನಿ. ಯಾವ ಟೈಮ್ ಸಿಗುತ್ತೆ?
ರೀಚ್ ಆಲ್ my lord, ಹಿಂಗೆ ಬರ್ತಾ ಇದೀನಿ my lord.
Let us see. Yes.
Seal number 62, my lord.
60.
Number 62, covered by the judgment of this honorable court, my lord, made a mention. Physical education director has been denied the similar salary of the.
Yes, what is?
62, my lord.
Yes, 63.
63 on suspension case.
I
have been not suspended after initially a transfer order is issued.
No, that is there any stay here?
No, my lord, there's no information.
Yes, day after tomorrow.
You also have a preliminary list. It is not in DQ, not.
Yes, leave this matter in preliminary hearing day after tomorrow. Yes.
Lord, seal number 62, my lord. 62, my
What
lord,
is this?
physical education director has been denied the similar salary has been paid to teachers. It's covered by the judgment of this honorable court, my lord.
62.
And made a mention on the last occasion.
Yes, ready, mister. Is it covered, mister?
Covered
No,
ಅಂತ ಅವರೇ ಇಲ್ಲಿ ಈ ಆರ್ಡರ್ ಅಲ್ಲಿ ಹೇಳಿ they have passed the order, my lord.
ಯಾವ ರೆಡಿ ಇದಾವೆ ನೋಡ್ಕೊಂಡು you get ready for disposal, mister. Till next date issue emergency notice. ನೋಡ್ಕೊಳ್ರಿ ಅವ್ ಯಾವ್ಯಾವ ಇದಿದಾವೆ ಅಂತ. You get ready, mister. 3 ಜನ ಇದ್ದೀರಾ ನೀವು. ಏನಿದು 60 62 yes Tuesday. Yes, Tuesday, mister. ನೋಡ್ಕೊಳ್ಳಿ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಂಡು you have to read the file and come, mister. Yes, mister.
61 adjournments granted stay of conviction.
ಕೊಡಿ 61 ಕೊಡಿ.
You were selected for the job of secondary school teacher. Police verification prevents him from taking charge of that position, but interim order stay of conviction is there. Relevant portion, page 98.
Now, what is that you are challenging here?
Challenging Annexure A endorsement, which is preventing me from taking the police verification, which informs that case number 722 is pending. Sorry, criminal offense 722 is pending.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿ ನಿಮ್ಮ ಕಕ್ಷಿದಾರರು ಚೇತನ್ ಸೋನ್ಸೋ ಮೊರಪ್ 28 ವರ್ಷ ಸೋನ್ಸೋ
Acquitted for atrocity.
ಆಯ್ತು ಅಲ್ಲ ಇದು ಏನಾಯ್ತು ಇದು ಏನು ವೈದ್
And stay of conviction as well.
ಅಲ್ಲಿಗೆ ಬರ್ತೀನಿ. ಇದು ಫಸ್ಟ್ ಏನ್ ಕೇಸ್ ವೈ ದಿಸ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಯು ಜಸ್ಟ್ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಿ.
On rank number 2 he got selected for the post of primary teacher. Process the next steps is document verification and police verification. Documents were accepted, police verification said this case is pending, therefore they are not accepting him, they are not allowing him to take charge of that position. But in the meanwhile the coordinate bench has given stay of conviction.
No, if it is conviction, if you see, if you have any criminal case, you are not entitled. No, if there is a conviction is stayed also, see, it is not that in government appointment, what is the rule is that if there is any criminal case, you are not entitled. If it is convicted, just because it is stayed, then you are also not entitled, mister. That's what that law, I think.
Produce the Supreme Court judgment.
You produce that judgment.
It refers to in the judgment of the coordinate bench, page 97 and 98.
What is that they say?
I'll produce those copies.
See, in that departmental inquiry, dismissal and different. In recruitment is concerned, if there is any criminal case is there, you are not entitled. Whether have you disclosed that criminal case in that?
Been disclosed and it has subsequently the stay order has also been produced.
No, when application have you disclosed that there is a criminal case?
Yes. The application form is
Then,
I'll produce immediately.
now judgment what you have to be produced is that in the recruitment, don't produce in that departmental inquiry and all. Departmental inquiry stay adre reinstatement ide. Recruitment is concerned, if there is a criminal case, you are acquitted, that charges, that acquittal order has been, conviction has been stayed, you are entitled for a recruitment, you have to be shown. If that be the case, yes. This matter, On 26th. Yes. Yes. Yes, Mr. 30th. Yes.
My lord, ಮಾಡೋದು ತುಂಬಾ ಕಷ್ಟ ಇದೆ, my lord, ತುಂಬಾ ಜೀವನ
Let us see, we'll see on the 30th. Yes, yes,
my lord.
yes.
ಬೇಗ ಹೇಳಿ ಬೇಗ ಹೇಳಿ ಬೇಗ ಹೇಳಿ ಎಲ್ಲಿಂದ ಬಂದಿದ್ದು? ಏನ್ ಮ್ಯಾಟರ್ ಅದು?
ಅಲ್ಲ ಇದು ಮೇಡಮ್ ರಿಟ್ ಪಿಟಿಷನ್.
ಹಾ ಸರ್
ಇಲ್ಲ ಮ್ಯಾಮ್ ನಾಳೆನೆ ಬೇಕು.
ಮಾಡಿಲ್ಲ ಸಬ್ಮಿಷನ್ ನಾನು ಹೇಳ್ತದನ್ನ ಹೇಳಿ ಹ್ಯಾಂಡಲ್ ಅದು ಸೈನ್ ಆಯ್ತು ಇವಾಗ ಹೋಗ್ತಾ ಇದೆ ಇದು.